Good morning, or good afternoon, ladies and gentlemen. This is the December 11th, 2019 formal hearing of the Utah Board of Oil, Gas, and Mining held in Salt Lake City, Utah. Our first agenda item is docket number 2019-024, cause number RMNLRL, Romeo Mike November Romeo Lima 2019-01 in the matter of formal rulemaking to amend the minerals program rules pertaining to suspension of operations. We'll take appearances of counsel.
Thomas Kessinger, the Attorney General's Office for the Division of Oil, Gas, and Mining.
Anyone else? Seeing none, Mr. Kessinger, would you proceed?
Thank you, Mr. Chairman. This is a formal rulemaking matter, and I think mostly I'm here just for moral support. Dana Dean has a presentation that she'd like to give and just introduce that into the formal record.
Proceed.
Thank you. I'm Dana Dean, Deputy Director of the Division for the Mining Programs, and I am just going to go briefly over the history of this rule. In 2015, Sarah Fields, who is with an organization called Uranium Watch, brought to our attention some concerns that she had about a uranium mine in her area where she lives. And as we looked into how to assess what she was asking about and how to proceed in getting that operation into compliance, we realized that the definition of suspension in the minerals rules is unclear, and it led to some mines accepting the division's interpretation of that rule and moving forward with coming before the board and doing certain things, and other mines not accepting that, and it became inconsistent and unfair. So the division started to look at drafting a rule to change that definition. I learned from this process, get people involved early, because we had a draft rule that we distributed on June 12th of 2017 that had not been vetted as well as I would have liked to, or the way that I would do it now. And we ended up with many comments on July 11th, 2017, and they were all in criticism of the changes that we were making at the time from both sides. So both the Utah Mining Association and Uranium Watch supplied comments. The comments were too disparate to try to pull together and get something to move forward with. One of the things that the Mining Association was concerned with at the time, we also tried to add some changes to the annual report that were of concern to industry, that it may give proprietary information. So we went back to the drawing board, decided to just look at suspension, make sure that we were just clarifying the definition of suspension and making the rule consistent with the statute, which means that there is no longer a requirement to come to the board unless the division finds that a mine is not following the rule and keeping in contact with us and doing the things that suspension requires. But anyway, at that time, we started to have new meetings and opportunities to discuss this. We had separate meetings with the Utah Mining Association and Ms. Fields. We took input from her as far as we could. A lot of the things that she would like to see done would be more of a statute change than a rule change, or were possibly outside of the scope of this, but I'll let her speak for herself when the opportunity arises. And then towards the end of the rulemaking, we involved some of the board members who have expertise in mining and mineral operations to give their input on the draft rules. We published the final draft after the October 23rd board hearing. The division asked for permission to go into formal rulemaking. The board approved that at that time, so we published a final draft that included some edits that were pointed out by Ms. Fields on December 1st of 2019 in the bulletin of the Division of Administrative Rules. This was forwarded to the board members and interested parties, and today is the official hearing and opportunity for public comment, so that this can be on the record, and those who would like to comment can comment on the record. The division feels that this version of the rule makes our duties and the requirements for operators more clear, and it makes it easier for us to move forward, knowing what is expected from both parties, and it makes the process more efficient. And we would hope that the board would approve the rule in the form that it was published on December 1st. If you have any questions, that's the end of what I had to say.
Before you have a question, I have just one procedural step, Mr. Kessinger. According to our rules, for a witness to testify electronically, there has to be a motion. Will you please make a motion?
I move that Ms. Fields be allowed to testify electronically in this matter.
Board members, any objection to that? Seeing none, that's granted. Okay. Board members, any questions of Ms. Dean? Okay, then I think, Mr. Kessinger, is your plan we go to Ms. Fields?
I believe that's appropriate.
Okay, Mrs. Fields, you're on. Can you hear us?
Yes, I can hear you very well.
And we can hear you as well. Would you please proceed?
Yes, my name is Sarah Fields. I'm with an organization, Uranium Watch, in southeastern Utah. Current address is in Monticello, Utah.
Could you give us your
Thank you.
full address, please?
Uranium Watch is P.O. Box 1306, Monticello, Utah 84535.
Thank you. Proceed.
Thank you for this opportunity to address the board regarding proposed rules affecting hard rock mines in Utah. And thanks to Paul and Tommy for getting this video link set up and for their patience. I'll go over some of my concerns, and I will also be submitting more detailed written comments. While the proposed R647 rules are an improvement over the current rules in some respects, I do have concerns. First, it would help to have a background document describing the current state of affairs with respect to the suspension of operations of mines in Utah. It would help to have an analysis of the length of time the mines have been on standby and the problems at the mines that have been non-operational for extended periods of time. There are some uranium mines that have not operated since the 1980s, or one has last operated in 1990. The proposed rule would still allow a small mine, including small uranium mines, to remain in a non-operational status indefinitely. That has meant that reclamation will be delayed indefinitely as long as certain conditions are met. I wanted to give an example of a small uranium mine operation, and that's the Sage Mine in Summit Canyon near the Utah-Colorado border in San Juan County. The mine last operated for a short time in 1990, 30 years ago. Previous to that, the mine had last operated in 1981. Although the mine is on Bureau of Land Management land, the mine operator has never submitted a plan of operations to the BLM, and so the BLM has never approved the required plan of operations. They were required to do that in 1981. The mine operator has still not submitted a plan of operations to the BLM. Therefore, the mine cannot legally operate, and yet is under oil, gas, and mining regulations. It's a mine on standby. And there have been hazardous conditions at the mine, including an open collapse mine. The portal at it, there was just a big collapsed hole when I made my first visit to that mine. It has since been plugged, but who knows how long that hazardous condition was there before someone noticed it. There were open buildings. There's waste rock dumped down the side of Summit Canyon. And as far as I know, there's still not a stormwater runoff plan. So for this mine, the rule would not really change anything. Even though it can't legally operate, it can still remain on standby under division rules, thereby delaying reclamation indefinitely. As long as the mine owner pays the fee, submits an annual report, and maintains the surety, and maybe does a bit of required reclamation work. So I think that the new rule should not allow small mines, particularly uranium mines, to remain on standby indefinitely. Division should withdraw a notice of intent for a mine that is not fully permitted to operate and where there has been no removal of ore for 3 decades. Another concern is the lack of a requirement to report suspension of operation for the first 2 years. The rules do not require the mine owner to monitor and maintain the site for the first 2 years. Therefore, the division might not be aware that the mine operation is ceased or that there might be hazardous conditions at the site. This is especially of concern for uranium mines where radon ventilation shaft and mine portals may remain open and other health and safety hazards could remain unaddressed. The Bureau of Land Management requires an interim management plan, which kicks in whenever a mine goes on standby, not 2 years later. I feel that the division should have a similar requirement. It is confusing when 2 agencies have different requirements when a mine shuts down for an indefinite period of time. The BLM also requires that a mine operator notify the BLM when a mine goes on standby. And I've noticed that at least for the LaSalle mines, and I believe the Rim mine, which went on standby in 2009, and then the LaSalle in 2013, that I did notify the division when they went on standby. And I think it's clearly an easy rule to comply with, to have a mine operator send a letter or otherwise communicate with the division when they go on standby, unless it's just going on standby for, let's say, because of winter and lack of access due to bad road conditions. I still do not feel that the rule clearly defines ongoing operation and shutdown. I do not know that if a mine owner, after years of operation, does a bit of exploration drilling and drills a few groundwater monitoring wells and does a visit of site cleanup, if that mine is now an ongoing operation, or whether ongoing operation really means continuous development of the mine at the beginning of the operational history of the mine, and if it means they must be continually removing ore or otherwise engaged in activities at the mine site. That is really unclear, particularly when I think of specific mines that are now considered to be on standby, that have gotten an extension for their standby period. Yet anyone who visits the mine would observe that the mine is really not operational, has been more or less abandoned, where equipment's been removed, and the mine owner really has no intent of ever reopening the mine. And there's also a question of the Mine Safety and Health Administration, because if a mine is operational, MSHA conducts at least 4 inspections a year. But if a mine has been shut down, then they don't do any inspections and they consider it to be abandoned. And it's hard to understand how the division can consider a mine to be an ongoing operation when MSHA considers the mine to be abandoned and does not conduct any health and safety inspections. Just a few more things. The division should require that a mine owner receive official approval in order to return to active mine operational status after they've indicated that the mine has gone on standby. The rules that are applicable to large mining operations to a great extent will be dependent on the discretion of division staff. The division staff needs funding and additional staff members to do their job. I think that the board and the legislature should give the division the tools, the funding, and the staff that they require. Thank you. And any questions?
Mr. Kissinger, we're going to go to questions of the board if you have no objections.
I don't have any objections to you moving to your questions now, but I believe Ms. Dean would like a chance to respond to the comments that Ms. Fields just raised.
All right, let's first go to questions, or would you rather wait till after? Okay, let's go to Associate Director Dean.
Thank you. I'm not going to respond point for point. I didn't take notes. I do appreciate the comments that Sarah made, or Ms. Fields. They're good comments. They are things in many cases that we thought about while doing this rulemaking. For example, if a mine is in suspension for a long period of time and they do plan to come back into operation, and their plan is outdated or any rules have changed in the meantime, they're already required to come in and amend their plan in order to go back into operation. So that's part, we've talked about that. That's part of the rules already. There's nothing that exempts a mine whose plan might be from 1980 from updating that to 2019 before they go back into operation. If someone's in suspension, that does not mean that we are not inspecting. In fact, we may keep a closer eye on some of these operations, knowing they're in suspension, and they may not have daily people there keeping an eye on the site. If the site begins to have environmental problems or becomes public safety hazard, that would prompt the division to feel that the company's not doing what they should to be able to remain in suspension, and we would bring that case to the board and ask for approval to either get them in compliance or take their permit away. So a lot of the things there are very good points that have been brought up, but they're considered otherwise. Another thing that we notifying us immediately of a suspension is difficult because a lot of times you don't plan to be in suspension for 2 years when you first go into suspension as an operator, and you certainly don't plan to be in suspension for 30 years. So notifying immediately, we have no problem requiring that, but sometimes an operator may not know how long they will be, a certain operation will be down. So the division wouldn't be opposed to that as long as it doesn't become overly burdensome. Another thing that we tried to avoid was the division becoming experts in economics and commodities and reviewing people's business plans. And I think the suspension statute and rules are meant to to take permits away from operations that are not responsive to the division and who are not following their plan and keeping their sites safe and from affecting the environment. And with the tools we have, we can go after those operators that are non-responsive. The division should not be deciding if someone thinks that something's an asset and if market conditions change, and they're willing to spend the money and time keeping that site in the condition that it needs to be in compliance with their permit. We don't feel that the legislature under our statute wanted us to go make those decisions for a company. The board may feel otherwise, but we did consider this in the rulemaking. We spoke about it quite a bit with the Utah Mining Association and with the board members who helped us with the rulemaking. So a lot of the points that Ms. Fields brings up are excellent. Some are covered in other areas of the rules. Some are just inconsistent with statute. But if the board would like us, once we get Ms. Fields' comments in writing, if you'd like the division to respond in writing or explain something further, we'd be very glad to do so.
Okay, we'll go to the board. We're going to start with Mr. Brown.
Ms. Dean, I have a couple of questions regarding status of mines, and I know that there's different kinds of mines. You hear me okay? Okay. Uranium is locatable under the mining law of 1872, correct?
I am not an expert on the mining law of
Well,
1872.
it is.
Yes.
I believe it's
Okay. I will
locatable.
trust you on that, yes.
Okay, so
Yes, it is.
if it's on federal lands,
Right.
it is locatable and held with a mining claim, correct?
Yes.
Can be it's not a placer, it might be a load, I don't know, but to be a mine, it has to have an approved plan of operations. Is that correct?
Yes, to be an operating mine.
Be an operating mine, it
Yes.
has to have an approved plan of operations, which includes an approved reclamation plan.
Yes.
And for these claims to be valid, they have to pass what most of us in the mining business call the prudent man's principle, which means they're economic to develop.
Yes.
I suspect most of these mines go into suspension because it isn't economic to mine the resource at this current time. And the hope is that they'll be able to realize that economic later. I guess what my question is, has anybody, I assume that these people are still paying their maintenance fees for these claims, and if they are or aren't, they have no valid claim. Do you know the status of any of these mines in that regard? Are they patented? Are they owned in fee? Are they held? These are critical issues to understand.
Right. So we have that data. I don't know that off the top of my head, but I will tell you that in the division's review of these and our analysis of whether or not these should be able to continue in suspension, whether or not their claims are valid is a very important point. And that's something that the BLM, they review that. They're the ones that take the payments and decide whether these should be extended, whether it's a lease or a claim. No matter how the mineral is held, that's something that we review. And if they let those lapse, then we're more likely to come to the board and say, these people are just trying to avoid reclamation. So there's avoiding reclamation, and there's, like you said, we're in suspension because we think this is a valid asset. We're maintaining it in every manner that we can, and we expect in the future for this to be an economically viable operation that will be of value to our company. So we're spending time and money maintaining this, including maintaining claims and leases. Those are the types of things we look at when we're evaluating this. I don't know the exact status of any certain mine. I would have to look that up, but I could tell the board that if you want that information, we could give you a table of that, or any specific operation you want to know, we can find that out. But that is one of the things that we look at. And if all right of entry is gone, or you no longer have a viable claim, or the landowner, whoever it may be, has told you to go away, we're more likely to pull a permit than to say that this person is honestly and reasonably in suspension and just waiting for an economic change or a change in commodity prices or something that would make that an operation that they want to operate.
Okay, well, I would suggest at a minimum, we ought to understand how the mineral resource is being held, what kind of claim it is. Has the federal government done any mineral examinations to determine if it's a valid claim per the prudent man's principle? If those things are all yes, and they are, then I see, further cause for legitimate suspension of operation. But if the resource isn't economic to mine and doesn't pass the principle, I question whether or not there can even be a locatable mineral there.
Right. So again, that would be something that the BLM that's their jurisdiction to decide whether or not to maintain those claims. And we would just know whether or not those are being maintained properly through the BLM's process. And if they are, for us, that is a positive that the operation plans to do something in the future. And if they let those lapse, or the BLM takes them away, or it could be SITLA or a private landowner, if there's no longer an access to the resource because someone else said this is not your resource, we would not allow that to remain in suspension. They have to prove that to us as well. But we're not, BLM would be the one making their own decisions, but we would take that into account. If you want that status for any certain operation, the ones that Ms. Fields mentioned, we can get that to you. Paul Baker may know, he's still here off the top of his head. If he.
Paul Brown, can I
Paul's
ask you a
back there.
question?
Yeah.
Are you suggesting that it be in the rule? Ms. Dean is saying that she can provide that, but it shouldn't, I think, and I agree with you, I think that what you're saying is that some of this needs to be available to the.
My whole point of query is to know if the mine is legitimate.
Right. So,
If the mine is not legitimate, it can't be suspended. It just doesn't exist.
and the division 100% agrees with that. And so, once we know that an operation is in suspension at least 2 years, we would ask for information, including, do you have a legitimate lease? Is this something you're maintaining? Like I said, we're not going to stop inspecting just because someone's not operating. So there are many factors that the division would consider in whether or not to allow a company to stay in suspension or not. And that's one of them. We have that information. Most of this information is available publicly on our website. I just don't know it off the top of my head for any certain mineral operation. We have lots of permits. Like I said, Paul Baker may know for the exact ones that Ms. Fields has mentioned. But those are things that we would be looking at. So what we were trying to do with this change in the rule was make it more clear what needs to happen when you are in suspension for a certain period of time. And then the division now knows we need to make sure that this is a legitimate operation, and there are many factors that we'll look on that. We didn't want to make those prescriptive and have a list of these are the things we'll look at, because they may be different for a small mine with industrial minerals versus a large metals mine or something like that. So we didn't want to make them overly prescriptive, but these are the types of things, the things you're concerned about, or the types of things that the division would take into account on whether or not to take action and get that mine from having a permit. So it wouldn't be allowed to stay in suspension unless we have clear proof that this is not an attempt to avoid reclamation or obligation. They would have to continue to increase their surety every 3 to 5 years as required under the rules. They would have to continue paying permit fees, filing annual reports, be in compliance with the BLM, keep their leases. There's a myriad of things that they would have to do that we would be checking, but we have a list of people who aren't doing any of those that we will immediately, upon getting this sorted out, that we'll be bringing to the board and saying, these people are obviously avoiding reclamation versus this is something that should be allowed under the rules to stay in suspension because it's of economic interest to the company and they do have future plans to mine it.
Oh, so Chris may have answered my question. I apologize, Mr. Chairman, but do the rules have a check and balance on the legitimacy of the mine, first and foremost? Before you, go ahead.
Before you can obtain a permit or maintain a permit, you have to have access to that mineral.
Yes,
So if you lose that access, your permit is essentially null and void.
yes, yes. So if it's a BLM lease or locatable, leasable or locatable, they're the ones doing the economic test. We are not, if someone comes in and they say they have a gold resource and they want to get a permit and they think it's economic, that's not something that's in our rules at the beginning of a process of whether or not that's a real business venture. That's up to the private venture and whoever wants to invest in that to decide whether or not that's a legitimate operation. We just make sure they have a legitimate lease and right of entry to the property and that they are following all of our rules. We don't make economic determinations. Once it goes into suspension, we're still trying not to make too nuanced or detailed economic decisions, but a company would need to tell us this is why we think we're probably going to be able to come back into operation in the near future. And one of the board members, Mr. Borden, suggested that as time goes by, maybe the first time we review this at 5 years, the bar is a little bit lower than when they come back 5 years after that. And that if they still have the same story and nothing's changed, we would be more skeptical about whether or not this will ever be something that they plan to mine again. So there's a lot to look at. We definitely would be reviewing all of that and trying to sort out what's a legitimate operation versus what's an attempt to avoid reclamation. But I think right now we have a lot of obvious examples of attempts to avoid reclamation that we would like to move forward on. And we will definitely take into account and concern any public comments, including from Uranium Watch. But we have done a lot at those mines. But anyway, the BLM decides whether or not a lease is viable or not. We don't. But if they don't have that, they cannot mine under our regulation.
So if their mining claim lapsed, how would you become aware of that? The division?
Either through the Bureau of Land Management letting us know, or inspecting records ourselves, or if the BLM terminates a lease, they generally include us on the recipients of notice of termination.
Brings up another question, Ms. Dean. When you
Closer, please.
when you perform an inspection of a hard rock mine site, do you also review their documents? Whatever documents are required for you to give them a permit. Do you have a complete inspection like they do under SMACRA at times?
It's not the exact same as SMACRA, and so records may not. I agree with one comment that Ms. Fields made, and that's that we need more people in the minerals program. So we may not be able to review every mine site every year. And the inspector is the inspector every visit is as complete an inspection as they can make at that site. So we don't have partials and completes like the coal program does. So every inspection they do is as complete as they can make it. I will say we're very much in contact with the BLM. We're aware of operations and situations where they have concern, and we try to put that at the top of our priority list, or other landowners that have similar concerns. So we try to keep in contact, but those are things that our inspectors are thorough, and they're keeping abreast of these issues. And when they go to a site, they do as complete an inspection and record review as possible.
Thank you.
Any more questions on the right? Okay, we're on the left, Mr. Borden.
Yes, Ms. Fields had raised a concern that small mining operations could fall through the cracks in the first 2 years that they're in suspension. Hear me out just a moment. But just looking at the text for the notification of suspension or termination of operations, the first clause states that all mine operations are required to be maintained in a safe, clean, and environmentally stable condition. I assume that covers whether they're operating in
Yes.
suspension or working through closure. Is that
Yes, it
correct?
doesn't matter the status of the permit, they still need to maintain a safe and environmentally safe site.
So that's the safety net that doesn't allow things to slip through a crack.
Yes, but again, I will say, we do not have enough inspectors for the amount of mines that are out there. And so she's correct that an operation may not be seen for 2 years if we're not informed of some other way about that. And so what we tried to do with this rulemaking was to change one thing that the rulemaking does do is change the annual report. And if you did not operate that year and you are beginning a suspension, that's supposed to be noted in the annual report, and then we're on alert to put that higher on our inspection priority list. I will say, knowing that we probably aren't going to get a ton of new inspectors in the future, we're using the same principles from what oil and gas is doing, where it's more of a risk-based inspection, and we're using GIS and data to help decide where our time is best spent. And so we hope to get to these types of things more quickly. If someone does not file an annual report, that raises a red flag as well. So we're trying to make it so that it's easier for the operator to notify us by indicating it in the annual report. If they don't file an annual report, then we're alert that we need to check that, and that makes the inspection priority higher. It is conceivable that we may not make it to a small mine within 2 years because our biggest priority are large mines, and we try to get to small mines as much as possible. But we're trying to remedy that both through the notification process and by improving our inspection prioritization using data. So I hope that that's addressed with the change in the annual report. Again, as I said at the beginning, the division is not opposed to requiring notification earlier in the process from small or large mines. We did not end up putting that in the draft rule. We put it in the annual report instead. But if the board wanted to require a letter as soon as someone starts a suspension, that's not just a seasonal suspension, but they expect it to endure for a year or more. That doesn't seem overly burdensome to me, but we thought the annual report would be less burdensome.
Mr. Moon?
Is there a question in the annual report about a valid claim or lease that they've maintained that? That would be a good place to ask it if it's not already asked there.
I don't believe so, yeah. And we have not changed the annual report form yet. We're waiting for the rule to go through,
That'd
but
be an easy thing to change and
Yes.
just add that, and then they'd have to at least self-report whether they've maintained their lease or their permit or claim.
yes, that would be a good place to do it if it's not already there.
We'll come back to you, Mr. Kessinger, but we would open this at this time for public comments. Is that how you see this proceeding?
I don't believe there's any further comment from the division at this moment in time. I know there's representatives from the Utah Mining Association in the room,
I would ask you to
Perhaps.
come forward
other interested parties.
and remind you to speak close to the microphone so that it's recorded. Please identify yourself, your address, and who you are, and
My name is Brian Summers. I'm the president of the Utah Mining Association, and I appreciate the opportunity to address the board in support of this proposed formal rulemaking for the minerals program's rules pertaining to suspended operations. The ability to suspend active mining operations is a critical tool for mining companies in order to respond to fluctuations in commodity prices and other market signals, as well as changes in larger macroeconomic and business conditions. Simply put, without the existence of rational and predictable process to suspend operations, the climate for investing in Utah's mining industry would become less favorable. Utah Mining Association operating members are also good corporate citizens and are proud of their exemplary record for safety and in mitigating the environmental impact of their operations. Therefore, the mining industry recognizes the importance that rules governing suspended operations must ensure that appropriate safeguards for the safety of the public and for the environment continue to be reported, monitored, and enforced by the division. The Utah Mining Association has been involved in the development of this rule for over a year. The rule development process has been a model of both the healthy tension and good faith collaboration that I believe should exist between a regulatory agency and the industry that it regulates. We're grateful for the leadership of Director Baza and Assistant Director Dean, the efforts of division staff, and the time and attention of board members who participated in this process. I also would like to thank Denise Dragoo of Snell and Wilmer and Chad Baker of Parsons, Bailey, and Latimer, who assisted in representing the Utah Mining Association and its operating members throughout this process. We believe that as a result of the careful and thorough efforts of the participants in this informal process, that the proposed rules align with the governing statute, promote transparency and information sharing, provide operators, regulators, and the public with greater certainty, and strike the appropriate balance between maintaining this important tool for the mining industry while providing appropriate protections for the public and the environment. Thank you.
any further comments from the public? Brian, would you submit the questions if there are any? Questions? Ms. Davis.
Mr. Summers, some of the mines that exist in Monticello have been inactive for over 20 years, perhaps up to 30, 35 years, and still in suspension. That seems like a long time in suspension. Do you have a comment about how long suspension should be allowed to exist, or when reclamation on such a mine should occur?
I don't know that I have specific comments as to an appropriate length of time, but I do think that the rules that are proposed here will give the division the ability to make those type of determinations, while again ensuring that there's appropriate safeguards for the public and for environmental protection while operations are in suspension. You know, as you know, commodity prices and market conditions unfavorable market conditions and commodity prices can persist for a long period of time in some cases. But again, we need to strike that appropriate balance between ensuring that, as Ms. Dean has mentioned, that suspended operations are not used as a way to avoid reclamation. But I don't know that I have a specific time period that I'd be want to put out there as what's appropriate and what's not for any particular operation.
All right, thank you very much. Question for you, Ms. Dean, then we'll go to you, Mr. Kissinger, unless there are additional follow-up questions. You've given a detailed explanation to Mrs. Brown and Hanson. How much of that is in policy, or how much of that is in rule? Is it your policy to follow up on this, or is it in rule? And the direction of my question is letting people know the rules of the game before they play, and to have some sort of predictability about what those rules will mean. Do we need to put some of those policies into rules so that people know the rules of the game, or is there some way that if it's a policy, that policy can somehow be out there so people can know that's how you plan to manage the rules you're given? Could you respond to that, please?
Yes, this is all in rule. It's not in a separate policy. Again, the rule isn't super prescriptive, but it does allow us to make the kind of determinations that we would like to. And I would like to, I think Ms. Davis's question was a good one, and I'd like to point out that we're again waiting to have this definition of suspension clarified before we take action on several mines. And I will not, I don't want to speak specifically to any of the ones that have been mentioned or any that we may have on our list, but there are things that the division would like to move forward with that we haven't been able to because this definition has not been clear and the rules of the game are not fair or clear because, as I said before, when we started looking at this and we started bringing mines that had been in suspension before the board, some people said, great, yes, we agree with your definition of suspension. Division will come to the board and we'll do what we need to. And other mines said that they didn't agree with our definition and it made it harder for us to move forward. So we want this to be a clearer definition. That's the purpose of this rule, is to make it a clearer definition, have an easier way to notify the division, and then make it so that we can go forward knowing the rules of the game, the operators know the rules of the game, the public know everything that we should be doing, and we can be more efficient. So that's what we're trying to do with this rule. We didn't want to get too detailed or change too much in the minerals program. We think that this is one simple change that can help us to really clear up a lot of operations as to what status they're in, and then begin to move forward on how do we either get them to reclaim or pull their permit or make sure that they're answering the types of questions that the board has asked today about whether or not they should be in operation and allowed to continue to hold a permit with the division.
Thank you very much. To you, Mr. Kessinger, as part of your remarks, will you comment on the primer or memo that you wrote concerning liability? I believe, is that associated with this issue? And what you would like to make sure the board gleans from that, so that the key issues that you wanted, you can do that however you want.
I don't think I would have a comment of it at this time. I think the rule that was proposed is the rule that the division supports, and that's the one that made it into the bulletin. So I don't feel further comment is necessary at this time.
All right. Are we to the board, or would you like to make closing arguments?
I don't think there's any closing arguments necessary here, and I think it'd be appropriate for the board to make a motion at this time.
Just so we're clear, Mr. Kessinger, the board has several options. One, they can continue to review this. We're actually in formal rulemaking. That they could continue to analyze it for a month and ask for clarifications. They can vote for it. What are the options under the Administrative Rulemaking Act with regard to how this board may move at this time?
So at this point, the comment period is open until December 22nd. So perhaps maybe a motion is not in order for the board at this time. So I think the board has done its duty and received public comment that the public has felt the need to present at this moment. In the future, the options generally are, if you're persuaded by comments that you've heard today, you could make a motion to change the proposed rule, in which case it would reset the essentially the procedure that we've gone through today, or you could move to adopt the rule as drafted and then move to file the document you need to file with the Utah Division of Administrative Records, or excuse me, rules, to make the rule effective.
Members, do you feel like you're clear on what your options are? Anyone want to make a comment on what option you would prefer us as a board to look at?
I'm not going to recommend an option, but I guess I would say I really appreciate being included in the process. And I did have some concerns, which I think you've allayed. I think the new rule's a huge improvement, and I feel like it's fair to the mining industry while also giving you a little bit more power to identify and act on sites that are truly closed and just never intend to reopen to avoid rehab. So I feel like it's a good balanced rule myself.
Anyone else want to comment on that? So as I understand it then, seeing none, as I understand it, the board can send this out for formal rulemaking, subject to comments that may come in between now and December 22nd, and that without any further comments and material changes to what we've heard today, there still can be comments, but unless there's some change in it, we're going to vote for that today. Is that the up or down, or? I'm not sure if, I'm not entirely clear where we are with in terms of the intent of the board.
No, I think we need to wait until the comment period is over.
Okay. So then, as I understand what you just said, the comment period has to close before we can take a formal vote. And that, is there any guidance that any of the board members would like to give to the division between now and the close of comments? Mr. Hanson.
My only comment is to go ahead and make the minor modifications that you want to make to the rule to tighten it up. That you mentioned you had some that you wanted to make. I see no reason that they shouldn't be done.
We're not hearing you on the microphone. Is it your mic on? I'm not picking you up, so. Would you restate that, please?
I'll try. I understand the division has some changes or minor modifications they want to make to the rule at this point.
No, what the changes we made are the draft rule. So we were tightening up the current rule with the draft rule. The draft rule is what the division would like to move forward with. We think it does what we need it to give us the power, as Mr. Borden said, to take care of some of these operations that we know are just avoiding reclamation. So our position would be to adopt the draft rule as is.
Okay, thank you. I appreciate that clarification.
Thank you.
Then we will continue this matter to the next board hearing, at which time comments will be, written comments will be considered. We would encourage all written comments to not only address the concerns that they may have, but also alternative language that they would propose, so that it can be clear what is being asked of this board. I don't know if we need a vote on that. With that, then, I think we'll end this agenda item, unless I'm hearing or seeing someone else raise their hand. Seeing none, then we'll go to the next agenda item. And just so you know, we plan to take a break at 10 after 3. So the next agenda item is docket number. Oh, Mrs. Fields, if you're still on the line, or if anyone from the division is able to get in touch with her, thank her for her remarks, and we hope that she will comment in person, we provide a written comment.
I'm on the line. Thank you.
Thank you, Mrs. Fields. Okay, we're going to go to agenda item number 2, docket number 2019-021, cause number 139-168, in the matter of the petition of Vitar Energy GP for a hearing to determine why Rivera Operating LLC, also known or formerly known as Lynn Energy Holdings LLC, and other companies have not paid oil and gas royalty proceeds. Okay. At this time, we'll take appearances of counsel.
Thomas Kessinger, Attorney General's Office for the Division of Oil, Gas, and Mining.
Chris Lacates, Holland and Hart, on behalf of Riviera Resources Incorporated.
give me your name again, sir.
Chris Lecates,
Okay. And how would you spell your last name, please?
Lecates.
Okay. This is a petition of, I believe, Vitar Energy. Are they represented here today? Then I'll take some advice from council on how do we proceed.
At this moment in time, I think it is appropriate for Ms. Weiser to present to you her presentation. And if Respondents Council feels the need to respond to anything, we should afford them that opportunity. And I believe there are members from VTAR present in the room today. However, I don't think they're prepared to participate in this hearing.
And they're not represented by council, as to your knowledge?
Yeah, to my knowledge, they're not represented by council.
And Mr. Kissinger, we'll have your side go at this time.
Okay, thank you. So, Chairman, members of the board set this matter for the division's investigation on October 1st. Ms. Beverly Weiser has conducted her investigation and prepared a brief presentation for you today. Ultimately, she concludes that further hearing in this matter is not necessary or not recommended. And with that said, I just ask that she be allowed to present this to you at this time.
Proceed.
Thank you. Can you hear me?
A little closer, please, and then identify yourself for the record.
Thank you. I'm Beverly Weiser. Do you need address, all that kind of stuff, or are you okay with the division?
Just state your state your position in the division.
I'm an audit manager here at
Proceed.
the division. We'll go forward. The board's responsibility is stated in Utah Code Annotated 40-6-9, and it tells us there that you have the responsibility to set to the division to do an investigation and negotiation to determine why the royalties were not paid, and if possible, to negotiate payment. The division's responsibility is to conduct this investigation and negotiation, and that we did. This is the first well that is in question on whether or not it received payment for royalties. It's a White 123C5 well. It's located in Duchesne County in Uinta Basin. It's a vertical well, and it began production on August 28th, 2015. The second well was the White Trust 323C5, and it is also in Duchesne County in the Uinta Basin and is a directional well, and production began June 19th of 2015. This is a timeline and that I've put together to try and help you understand the timing of things that happened. And so you see at the top, we've got 2015, and each of the years represented at 2019. The EP Energy, E&P Company LP, is the operator of the well. And Lynn had a working leasehold interest in those wells. And if you look at in this area, you can see my mouse, so you know where I'm at. In this area, you'll see that in May of 2016, Lynn filed for bankruptcy, and it completed in February of 2017. And Riviera became they're a spinoff of Lynn, and that kind of speaks for itself. In 2018, May of 2018, Altamont Energy operating LLC purchased the working leasehold interest from Lynn. And the red area right here represents the wells and the time period that royalties have not been paid for. And that's June 2015 to May of 2016. In June of 2016 to May of 2018, it appears that there was a suspense account that had been contributed to. And when Altamont purchased this leasehold, Vitar Energy and his group, because there's 3 cousins involved in that, and they're listed, they're the petitioners. They came to the division in 2018 and questioned why they hadn't been paid. And we contacted Altamont to find out why they had not been paid. And Altamont was very good to work with. They got with the petitioners, they worked with them, and they were able to figure out what was going on. And the suspense account was dispersed to those that it went to, as far as we know. And so back to these wells, the dates that the royalties have been missing on, we've got the suspense account. We couldn't verify whether or not anything was put in for those dates. The 2 wells are the White Trust, and unpaid royalties were from August of 2015 to May of 2016. And the White 1, 23C5 well, the unpaid royalties were from June 2015 to May of 2016. And the total royalty payments for all 3 of those petitioners and for both of those wells comes to about $150,000. It was a little bit less than that. Whoops. In our investigation, the division compares the production reports that were provided to us by the royalty holders or the petitioners, and the work and the working leasehold that was provided by EP Energy then to represent Lynn's portion of that production. And the top line here is this well production that was reported. That represents what was reported by EP. And Vitar production report is what was provided to us by the petitioners. The difference here is 22.86 barrels of oil, stating that the petitioners believe there was a little bit more than what was reported to the division, and 15,705 MCFs of gas. And remembering that these are oil wells, but the gas still has value on that, and that 15,705 represents that the production that was given to us by, I don't know if I said that right the first time. Yeah, I did. Okay, that what was reported was more amount than what the petitioner expected it to be. And looking at that in my comparisons, that represents 1 month of production of gas that was not on the petitioner's spreadsheets. Thank you. And down here you'll note that the division's routine operations and policies do not monitor royalty payments. So we don't see, what that means is we don't see what the royalty amount is and who's given what to who, and we don't monitor that. We don't have access to it. The division usually facilitates getting the parties together to discuss the disagreements and reporting and payment. And in this case, because Lynn went bankrupt in the courts in Texas on February 28th of 2017, this date was before the division was notified and before we were requested to help in the situation. Riviera is the reorganized company of Lynn. Lynn's management claimed that during Chapter 11 reorganization proceedings, Lynn Energy sold $2 billion in assets and generated enough in proceeds to repay all debt. Riviera Resources, Inc. news release seeking Alpha on April 10th, 2019 was where that came from. VTAR, or the petitioners, claim that the royalties on 2 wells for 1 year come to about $150,000 and that they were not paid. Riviera, or Lynn, submits counsel grounds for dismissal. Unpaid royalties during the period in question are invalid against it as an assignee out of the bankruptcy. Claims need to be filed in bankruptcy court. Claims for the period prior to their assignment must be pursued in the bankruptcy court, which has exclusive jurisdiction regarding claims against Lynn for the dates in question. The division compared production reports of, this is conclusions, that we'd compared the production reports of the royalty holders and the working leasehold for the periods of disagreement. Production compares reveals immaterial difference. This was a statement that was given to me by the petitioner, one of the petitioners, that it was immaterial. The division finds that any claim prior to the completion of Lynn's bankruptcy in February of 2017 needs to be settled in the bankruptcy courts, and that the division and the board have no jurisdiction over the bankruptcy issues. There's one more slide. I know.
Proceed.
I guess there's actually two. This is negotiation that took place considering all of the information that was provided by both the petitioners and by the respondent. The division finds that the petitioners were not paid, as far as we know, the royalties that were due to them of about $150,000. However, the response from Riviera is believed to be a reasonable application of the law to the facts, and any claim should be pursued in bankruptcy court. The further investigation and negotiation would not be productive, and the division recommends the claim be pursued in the proper jurisdiction and that a future hearing would not be recommended.
Thank you very much. Any more from the division?
Nothing further from the division, but if Riviera feels that they need to respond, I would give them that opportunity now.
Rivera.
Rivera.
Mr. Lacates?
No response from me.
Okay, we're back to you, Mr. Kissinger, but if you could make it brief, I think we understand exactly where we are.
Yeah, exactly. So these claims were essentially should have been pursued in bankruptcy court. The board has no jurisdiction over those funds at this time. And again, we conclude that a future hearing by the board would not be recommended.
Well, the matter is to us, board members. The board does not have to set the matter for a hearing per Utah Code 40-6-9 sub 6A. And it also states that, quote, if the board does not set a hearing, any information gathered during the investigation and negotiation shall be given to the petitioner, who may then seek a remedy in a court of competent jurisdiction, close quote. That's 40-6-96B. There is a court of competent jurisdiction, which is the bankruptcy court. under the facts and circumstances alleged. I think we'd want to remind the division to provide the information as required by statute. The issue before you is to grant the division's request that there be no further hearings on this matter set before the board. And I would add that the effect of that is that to the extent the court requires some clarification that there has been an exhaustion of the administrative remedies before the state agency with jurisdiction, which is the Division of Oil, Gas, and Mining. So a motion at this time would be improper to grant the division's request that a future hearing would not be recommended.
I move that the division's request that we not have a further hearing on this matter be accepted.
Is there a second?
Second.
Board members, do I need to restate or any questions on that or comments? Okay, the motion before you is to grant the division's request that a future hearing would not be take place. All in favor say aye.
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 Any opposed? Let the record show that was unanimous. Okay, we're going to take about a 5-minute break. We'll go to Wesco operating. Thank you, Mr. Lacates. J.U., thank you, Mr. Kessinger, and the division. We'll go back on the record. So we are at docket number 2019-022, cause number 196-46, in the matter of Wesco Operating, Inc. 1 minute, please. We'll take appearances of counsel at this time.
Fred McDonald of McDonald and Miller on behalf of Wesco Operating, Inc.
Gordon Rowe from the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
And welcome to you.
Thank you.
Proceed, Mr. McDonald.
Thank you, Mr. Chairman. I understand from the board's direction, from board's counsel, and presumably with the division's concurrence that since this is an uncontested matter, that they will accept proffered evidence on that I would offer, and then we'll confirm it with the two witnesses that were here for Wesco.
Any objections to that, board members? Okay, let's go forward with that.
Okay, should the witnesses be sworn in just for their confirmation?
Yes, of course.
Okay. With me today are Mr. Steve Degenfelder, who's the landman for Wesco Operating, Inc., and also Mr. Tom Kirkwood, who's the petroleum engineer for Wesco. Would you swear them in, please, at this time?
Will you raise your right hands? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Chairman, members of the board, this is a matter that you've heard before. This is a situation of a horizontal well that's drilled within the boundaries of a federal exploratory unit. The well crosses boundaries of leases as well as the unit participating area. Under these circumstances, if the well does not meet what's called the unit paying quantities criteria under a unit agreement, the allocation from the well is on a wellbore basis, in other words, to the leases in which the wellbore traverses. Under these circumstances, the Bureau of Land Management requires a communitization agreement to properly allocate the production to the participating area of the unit and to the leases that are outside of the unit based on an order of the board. So we're here in front of you because the well at issue, the 12-2-2619 well, is a non-unit paying quantities well that Wesco has determined. So we're requesting today that the board create a special drilling unit for this well consisting of 400 acres. Unlike the other situations where we've had this before, the Bureau of Land Management has not issued a concurrence letter yet. But the presumption is that they will concur and they agree to the same methodology for the 400 acres, the determination of the area to be included in this drilling unit. It's based on precedent that's been done. Mr. Degenfelder would testify to the where the well is, the corporate status of Wesco. They're duly authorized to do business in the state and bonded. They've been in front of the board here many times. He would also testify the procedure under which the BLM requires this communitization agreement. He's also identified all the interest owners that would be affected by this drilling unit, which are the people in the participating area as well as the production interest owners and the 4 leases that are individually involved with the traversing of this well. He would also testify that the certificate of service was sent out, I sent it out of my office, that also that those people constitute all the people that would be entitled to production under this or may be affected by the area. The exhibits involved with the land issues are exhibits A through, I believe it's F. Yes, A through E, excuse me.
A through E.
E also represents the letter that Wesco sent to the BLM indicating that this was a non-unit paying quantities well and asking for their concurrence. And as I said, the BLM is yet to respond to that, although they did not file any objection or any response in this matter. With that, that would be Mr. Degenfelder's proffered testimony.
Can I interrupt you here
Certainly.
for a second? So we're talking about a divided type federal unit.
Correct.
That has a well that is not meeting the paying quantities definition as set forth in the unit agreement, therefore basically falls out of BLM jurisdiction. under 30 U.S.C. 226J, and then now is in our shop. Will you go through the exhibits A through E and tell us what those would have shown?
Certainly. Let me just correct you, Mr. Chairman. It doesn't fall out of BLM jurisdiction. The BLM still administers the unit, and there is a unit participating area. The issue is that you have to have a board order creating a special drilling unit before they will authorize and sign on a communitization agreement.
Thank you for that clarification.
Okay?
Quick question too. So even,
Your mic's not on.
so even though it doesn't qualify as a unit paying quantities, it's still held by production?
Yes, it's still a producing well.
Producing well, but so if it did meet that unit paying quantities, then we wouldn't have needed to have done this. And what would the spacing unit, what would it have been?
There's no spacing unit required. What would have happened, there would have been an expansion of the participating area by the BLM, and that's because the well, by meeting the unit paying quantities determination, allocates the lands that involved as being productive. And so it becomes part of the participating area, and it wouldn't require a spacing order.
Okay, but now that's no opportunity for that now, so we got to come back and make a spacing.
And to be clear, board members, there's several definitions of paying quantities. The two key ones in play here are the ones in the unit agreement and the one in the lease. In the unit agreement, to come under the unit operating or unit agreement, you have to be able to break even plus a profit. Under the lease, it has to be just break even, or that you can at least pay your operating costs at that. So there are different definitions. It still keeps the lease alive. I hope I'm not taking your thunder.
No, not at all. I want to make sure the board understands the reasoning here. Like I said, we have had previous hearings like this, but, to clarify these things, it's always good. Federal units can certainly be confusing.
The important thing here for the record is to show that this is paying quantity definition under the unit agreement.
Right, and because it doesn't meet that, that's why we have to do this. Going through the exhibits very quickly, Exhibit A was simply the vitae of the two witnesses. They've been qualified as experts both in petroleum land management and in petroleum engineering by this board on several occasions.
And they're so noted for the record.
Okay. Exhibit B is simply a reference map to show you the relationship of the King Creek unit and the well at issue to the city of Moab. Again, the board has heard about the King Creek unit many times, and this is just to locate that. Exhibit C shows the boundaries. I'll go to that real quick. Shows the boundaries. The red line represents the boundary of the unit participating area. And if you notice, there's 80 acres in Section 12 that are within that unit participating area. The green area is the proposed drilling unit. And you can see the other lands that are outside of the red dashed line are the leases that are involved here. They're still within the unit boundary, but again, they're not within the participating area. Exhibit D, there's no slide for, but that is a listing of all the production interest owners that would be involved here. And Exhibit E is the true and correct copy that the letter that Wesco sent on October 8th, 2019, asking for the BLM's concurrence that the well was a non-unit paying quantities well.
Division, are you through, Mr. McDonald?
I am with Mr. Degenfelder's.
Okay, thank you.
Would be his
Division, do you have
proffer.
any objections to those proffers?
No objection. Just a couple clarifying questions, if that's okay. First,
I'm not picking you up on the mic at all.
just a couple clarifying questions, if that's appropriate. First, the BLM hasn't submitted a letter, but under federal regulations, are they required to submit this letter of approval in support of your filing?
Mr. Degenfelder, do you want to answer that, or?
Mr. Chairman, we wait for their concurrence, but we've never had a situation where they did not concur with the spacing unit approved by the state agency that regulates that. So we regard their lack of response as no protest at this time.
Just one more clarifying point, and if this well were to start producing with unit paying quantities under the BLM definition, if I read the request correctly, that the order would be suspended?
Yes, that's the situation. It's highly unlikely that the well will ever produce unless there's a miracle rework on it. But if that was the case, then we would suspend this order, and that's consistent with what the board has done on similar situations.
Great. Anything from That's all from the division.
Board members, any questions of this witness? Let's start with you, Mr. Church.
I may have missed on your exhibits. Was there an exhibit with a surface location and bottom hole location?
Yes, it's coming in the other technical situation, but the surface location is in section 12, and then we'll show you where the landing point is and then where the terminus is.
Ms. Davis.
So if this well is not producing paying quantities, why are we doing this?
It's still producing, and you still have to deal with the production that it's at. It's just not meeting a profit level. It's still producing, and it's still holding the lease, and so you still have to deal with the production from the well.
So if you're talking in business terms, it's not meeting its capital requirements, but it's making money, I guess is what I'm trying to say. It's not meeting its break-even point, but if you were to shut it in, it's not making any contribution toward capital already expended?
It's paying for its operational costs. The unit paying quantities test calculates whether it can recover enough money that it took to drill and complete the well, both in tangible and intangible costs, and the operation of the well. At this point, as Mr. McDonald has said, that the well is will never reach that point where it recovers its investment costs, but it's still producing oil and gas. And to further answer the question that you posed initially, if this was a unit paying well, qualified, then that red outline would expand to include the green acreage. But it's not a unit paying well, it's a non-unit paying well. And so we have to allocate production based on that small area. And the BLM requires this be done in a unit area because in inside units, the spacing of wells is by the state agency is not required. But what they do require, if it's not a unit paying well, that in the event we quit drilling in the unit will contract down to the red outline. In that case, then you would have this production sharing area, being the green area, part of it sitting outside that participation area, which is the final unit area. And what the BLM requires us to do is to develop a spacing unit and then a communitization agreement for those wells that are drilled outside a participation area, but inside the unit. So if the unit ever contracts, then it is addressed how to allocate that production when these lands are no longer unitized, because the lands outside the participation area would not be unitized. Hopefully I didn't confuse more, but.
A little bit. So what you're telling me is it's meeting its variable costs,
Yes, ma'am.
but not its sunk costs.
Yes, it's not going to recover its sunk costs.
So no one is ever going to receive any royalties from this?
No, they'll receive royalties based on the amount of production that we get off of it. It just will never be enough for us to recover our investment costs.
Thank you.
Other questions? Thank you very much.
Mr. Chairman, a couple clarifications here. Also, when you asked about the exhibits, Exhibit Z is the copies of the return receipts showing delivery of the request for agency action.
As supplemented?
As supplemented, yes. It was supplemented on Monday. Also, just for the record then, Mr. Degenfelder, what I proffered as evidence, is that a fair summary of what you would testify otherwise?
Yes, it is.
Okay.
Thank you. Call your next witness.
Mr.
and
Kirkwood?
Proffer what you can.
Mr. Kirkwood is the petroleum engineer and again has been recognized as an expert in this area by the board on several occasions. His testimony would go to the fact of the stratigraphic definition of the zone that is being asked to be spaced here. He would also address the geology to show that the clastics that are involved here, that spaced area, constitutes a common source of supply. He would also provide, and we'll show you the exhibits, about the well itself, the well construction, which is one of the exhibits. Also the economic and reservoir characteristics of this well to show why it's not meeting paying quantities, the economics of it, and also the drainage area on which he used the parameters here to calculate the area for this spacing area. Here, Mr. Church on this exhibit, and I'll go through these exhibits again. This is showing where the surface location is in section 12. If you look at the center of section 12, that's the surface location. And then the landing point is right there on the red line between sections 11 and 12. And the circles that are shown are the drainage circles, and that's along the wellbore path. And that's, again, the methodology for the inclusion of the lands is consistent with what was done with the BLM before. And then the last couple exhibits are just, again, the economics to show the cash flow situation with this. Again, going through the exhibits that Mr. Kirkwood would testify to, Exhibit F is the log from the well showing the stratigraphic interval that is being asked to be spaced. Exhibit G is an isopac map throughout the area to show, and also the cross-sectional geologic line that's shown on the next exhibit. Exhibit H is the geologic cross-section.
Do you have those on your?
I do. Let me go back then.
Let's go
For
back.
the screen, okay. Okay, going back again to Exhibit F, this is the log showing the stratigraphic definition from the well. The spaced interval between 7707 and 7769 here are the clastics. Exhibit G, again, is the isopac map and also showing the cross-sectional line. That's the next exhibit. Exhibit H is the cross-section, geological cross-section. If you see the red area below, that's the Cane Creek clastics that we're talking about here through this whole area. Exhibit I is the wellbore schematic so that you can see how it was designed and where the perfs are, just so you have an idea of how that well was drilled. Exhibit J is the decline curve analysis. And Exhibit K are the drainage calculations and the parameters. That's a two-page exhibit. This was the first page and the second page. And again, the key to take away from this is the drainage circles along the wellbore to determine, and that was utilized to determine the area, consistent also with the BLM's methodology for establishing what would otherwise have been the participating area had the well been a unit paying quantities well. On Exhibit L, this is the map showing those drainage circles and also the wellbore path with the surface location in the center of Section 12 and the terminus in Section 14. And the green area, again, is the area that we're looking to be spaced. And finally, Exhibit M are economics, the monthly cash flow, and then the annual cash flow report, which show that why this has been determined to be a non-unit paying quantities well. Mr. Kirkwood, again, is that a fair summary of my proffer of what your testimony would be?
Yes.
Division, is that proffer okay? And then do you have questions?
No, we're fine with the proffer, and we don't have any questions. Right.
And then just as a advice, you need to be a lot closer to the mic. Relocate it if you have to.
Great, thanks.
Then does that conclude your presentation?
That would be our
Chief?
presentation, yes, Mr. Chairman.
Okay, we're now to the division.
The division does not have a case in chief. We support the request as filed, and I don't think we have any questions at this time. Thanks.
Okay, we're back to you, Mr. McDonald, to waive summation.
Yes, I'll waive summation. I just want to make sure the exhibits are admitted for the record.
The exhibits, any questions on that?
Before we go to summation, would you Mr. Kirkwood, would you go over the annual cash flow report?
Yes, so this is basically if you got the well at no cost and you had, your operating costs of it. So down in 2012.
Do you point to where you're referring just a little bit to help us?
Yep. So can we go back a slide? Yeah. So this is just on a monthly basis. It's a little easier to show. So basically in September, the well grossed 388 barrels. And then October, it made 3,872. And then this much gas at a price when that's sold after royalties, and that's sold at $45.75, and the gas at $1.50. That gives you a total of $141,000 for October. And then the operating cost, the average monthly operating cost of the well has been about $6,000 less your taxes, and that gives you what your operating income is for that month. And then it basically cumes it up as each month that it's cash flowing positive. Once your gross barrels aren't enough, or your net barrels aren't enough to cover your operating costs, that would be your basically the most that your well can make. At that point, you're losing money to produce your well, and that's the total value is $312,326 at the bottom there, with a life of about a year and 2 months.
Do you want to go to the annual one? Is there any?
So the annual basic.
But while you're on the monthly, so currently, like in September, your cash flow is negative. Is that right? Am I looking at that right?
September
2019. Here, do you need to?
Here, let me see. Yeah. Sorry, Mike.
Negative $440 in September.
September of 2019.
Oh, of 20.
Correct.
Yeah.
Correct. Yes, that would be a negative, and I would envision that's price. Let me see. That's because October has 31 days and September's got 30 days, so you have one more day of production in that month. So you've got. So you if you look at the gross barrels in October, you made 188 barrels. In September, you made 167 barrels. That's just the difference in the days of the month, 31 versus 30.
I guess what I'm getting at is you're either making negative or very little on this well.
At this point.
Yes. At this point, it's not making it is doing. So this was what was submitted to the BLM, and the run date on it is November 7th. But this is what was submitted to the BLM for the production on it. Going from that day forward, I'd have to look at what the current production is, but we've been averaging around 5-6 barrels a day. So I would say it's very close to breaking even, if not now. The difference is when this was ran, it was also at $53 oil, and currently we're at 58. So you get an extra $5 per barrel. So it's really hard. It can be really fluctuating. The only thing to say is that we're so far off of the drilling and completion cost was in excess of $4 million, and we're nowhere near that for unit paying status on it.
I understand that. My question is, why are we keeping this well operating if it's losing money every month?
So right now it probably is making money because we've got a higher oil price. This was run. It shows $45.75. Our deduct on our oil is $7.25. So that was $53 is what we used for a NYMEX price, and right now our NYMEX price is around $58. Another component is that these operating costs are associated to this well, but also to other wells in the unit. So if we pull, let's say of this $6,000 roughly dollars, $3,000 of it is going to be the pumper, their truck, their equipment, and that if you pull that off, that's going to be associated to other wells as well. And then the operating cost could be changed, but those costs can fluctuate between wells because you got one operator that you've got out there for so many hours, and if he swings by this well, it collectively as a whole it saves money.
Thank you.
Back to you, Mr. McDonald.
Okay, also, I just want to make clear too to understand that because the well is making production, royalty and overriding royalties are being paid here. So there is revenue going out to people. And so that's an important factor. Okay, Mr. Chairman, I would move now for admission of Exhibits A through M inclusive and Exhibit Z as supplemented.
Any objections to that division?
No objections.
Board members? Seeing none, they are so admitted.
Thank you, Mr. Chairman. I'll just waive my summary. Again, this is a fairly straightforward matter. The board's familiar with these, has done it in the past. I would ask that the chairman ask if there is a representative from the Bureau of Land Management here, if they wanted to state anything. Otherwise, we would ask that the request be granted as filed.
Is there a representative from the BLM that would also like to comment on this matter? Seeing none, thank you. We're to the board. A motion to approve this or some other action would be in order.
Sorry. I move that we approve this request.
Is there a second to that? Seeing none, it dies for lack of a second.
I would second it.
Okay, thank you. Any discussion? The motion before you is to approve the request as submitted. All in favor, say aye.
Aye.
Any opposed? Let the record show that was unanimous. Thank you very much.
Thank you, Mr. Chairman. I presume you would like me to prepare the order.
Yes, please prepare the order.
Thank you.
We're now going to skip over agenda item number 5 and go to agenda item number 6, which I'll read into the record at this time. We are in docket number 2019-027, clause number 194-03, in the matter of the request for agency action of Wesco Operating, Inc. regarding flaring of gas from the Blue Hills gas plant. Okay, we'll take appearances of counsel this time.
Fred McDonald of McDonald and Miller on behalf of Wesco Operating, Inc.
Thomas Kessinger, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Anyone else? Seeing none, Mr. McDonald.
Thank you, Mr. Chairman. Again, with me today are Mr. Steve Degenfelder, landman of Wesco Operating, Inc., and Mr. Tom Kirkwood, the petroleum engineer, and I would ask that they be sworn in at this time.
Proceed.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
The vitae of both witnesses were submitted on Monday as part of Exhibit 1. Both, again, have been previously recognized as experts in petroleum land management and petroleum engineering, respectively, but Mr. Degenfelder will just be testifying as a fact witness.
Okay. Is this, Mr. McDonald, a matter that a proffer would be in order with? Okay, let me back up. My counsel just told me that we do not want to proffer on a flaring up.
That was my understanding on this one, that we wanted to get through the testimony. Again, I would ask that since Mr. Kirkwood has been recognized as a petroleum engineering expert before, that he again be recognized as such, presuming there's no objection from the division.
No objections.
Both witnesses are so admitted. I think, did you ask for your first?
No, Mr. Degenfelder is just going to be a fact witness today.
Then Mr. Kirkwood is so noted.
Thank you. The board also granted the motion for leave to file the exhibits on Monday. I just want to make sure the board received all those. It's exhibits 1 through 3 and Z,
We did. Thank you.
in addition to the exhibits that were filed with the request. First of all, Wesco and myself would like to thank the board for granting the emergency order in this situation and allowing this matter to be heard on an expeditious basis. As was set out in the verified request for agency action, as today's testimony will show, these are extremely unusual circumstances leading to Wesco's requested relief and which justified the expeditious manner in which this has been handled so far. Again, Wesco is seeking board approval to flare up to 400 MCF per day from its Blue Hills gas plant, which services gas from Wesco's operated 18 wells in and around the Cane Creek unit. The need for flaring results from the Utah Public Service Commission's order shutting in the Greentown intrastate pipeline, which transports the gas from the plant to the interstate pipeline and to the end users. True and correct copies of the Public Service Commission orders and the Division of Public Utilities report relating to the pipeline shutdown were submitted as Exhibits A through C with the verified request for agency action. The problem here stems from Utah Administrative Code Rule R 649-3-20, subsection 8, which prohibits the flaring of gas from a gas plant unless made necessary by mechanical difficulty or of a, quote, very limited temporary nature. In addition, Utah Administrative Code Rule R 649-3-20, subparagraph 9, provides that in the event of a more prolonged shutdown, the division is to be notified and, quote, take such action as is necessary. While it was initially believed that the pipeline would be reopened very quickly, the PSC order has remained in place. I was advised yesterday by the Division of Public Utilities Assistant Attorney General that there's a hearing scheduled next week before the Public Service Commission on December 19th and 20th. But she also informed me that she didn't believe a final resolution is expected for at least 3 to 6 months. As a consequence, the division in mid-November instructed Wesco to seek board approval for flaring at the plant. Wesco filed the verified request for agency action in this cause in response. Specifically, Wesco is requesting the board to exercise its discretion under Utah Administrative Code Rule R 649-2-1, subparagraph 2, to grant an exception to the gas flaring plant restrictions and allow the requesting flaring until the Public Service Commission orders resumption of the Greentown pipeline. True and correct copies of the relevant regulations were submitted as Exhibit 2 on Monday. The board has jurisdiction over this matter pursuant to Utah Code Annotated 40-6-5, subparagraph 3F, and the previously cited regulations. The request was sent out certified mail return receipt request to the BLM, to the SITLA, and all the production interest owners in the 18 wells to their last addresses shown by the records. The status of those mailings is reflected by Exhibit C filed this Monday. Many have received them, but there's still indication that some of the people haven't picked it up yet. Given the expedited nature of this matter, publication did not occur yet. The School and Institutional Trust Lands Administration filed a letter in support of granting the verified request for agency action on December 4th, 2019. And to the extent that that's not already deemed part of the record, Mr. Chairman, we'd ask that also be included as an exhibit if necessary.
So noted, and yes, it will be admitted.
No other responses so far to the verified request have been filed, and the division has not filed any staff memorandum on this. With that, I'll start my examination of Mr. Degenfelder. Mr. Degenfelder, please state your name and address for the record.
Steve Degenfelder, land manager for Wesco Operating, Kirkwood Oil and Gas, 120 South Durbin Street, Casper, Wyoming, 82602.
And do your landman's activities include the records inclusive of the Cane Creek unit area?
Yes, they do.
Okay. Would you please state for the record the corporate and bonding status of Wesco?
Yes, Wesco is a Wyoming corporation in good standing with principal offices in Casper, Wyoming. Wesco is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all federal and state of Utah regulatory agencies.
Mr. Degenfelder, now I'm going to show you what is the certificate of service, which is a pleading on file in here, and there's several parties and their address is shown. Do you recognize who those parties are?
Yes, I do.
And who are they?
They are the all parties that would be affected by by this application.
In the 18 wells that?
Yes,
Okay.
in the 18 wells from the participation area, and those names were gleaned from our records in-house as well as county and federal records.
Okay. And Mr. Chairman, again, Exhibit Z represents the return receipts and the Postal Service inquiries of the status of the mailing of the request that was prepared by my office. With that, that concludes my examination, Mr. Degenfelder.
Division?
Okay, at this point, I'd ask that division staff gets to ask a few questions.
Please, Mr. Degenfelder, would you come back, please? Proceed.
Yeah, Dustin Doucette, Petroleum Engineer for the division. Just a couple questions as far as future plans in this area. Do you have any plans to drill any additional wells or recompletions? And some of these may be for your next witness, but if you know that answer, maybe it kind of leads into my next question.
Mr. Chairman, I would defer those answers to our petroleum engineer. That most of my testimony is related to land and some regulatory, but mostly.
Okay, so that kind of goes into my next one, and maybe you can answer this one. Are there unit obligations to drill wells in this unit, and if so, are there stays to those obligations until flaring's remedied, or what are the consequences of what you're required to do in the unit?
Yes, the King Creek unit was established many years ago and went into what BLM calls a Section 2E status, which requires continuous operations be conducted, and then that phrase was modified by our predecessors, Fidelity, and they had that amended to read continuous activity would be to drill and complete 2 wells per calendar year. We drilled a well this year, and that really we were waiting for the completion of an environmental impact study on other locations to the northwestern part of the unit, and pending the approval of that EA, which is ongoing with BLM. BLM has given us a suspension based on that unavoidable delay, continuing that continuous activity. So, in answer to your question, we do not have any current drilling obligations right now, but that's not because of the flaring issue. It's because of the preparation of the environmental assessment for those wells in the northwestern part of the unit.
Okay, thank you.
I just have one question at the moment. The comment letter submitted by SITLA states that the flaring results in avoidable waste, but currently you're characterizing this waste, or this flaring, excuse me, as unavoidable. Could you just speak to why SITLA would support this request, but also state that it's avoidable?
If I can answer that on a legal basis, I think what's meant is that but for the pipeline shutdown, the gas would not be in a situation of being unavoidable waste, or it would not be if it was going through the pipeline. It's the pipeline shutdown that's causing it, and because of that, it's beyond the reasonable control of Wesco. They're supporting it because they understand the circumstances, and they're still being paid the royalty, which will be addressed in Mr. Kirkwood's testimony.
Okay. Yeah, at this time, I think I have no further questions for this witness. Thank you.
Board members, any questions? I think there's one that we want to double check, and that is because it's unavoidable, the royalty, even though there's not income coming to Wesco, the royalties are still being paid to SITLA. Could you respond to that?
Mr. Chairman, yes, that's correct, that the royalties are being paid to the federal government and the state of Utah while this period of time that we wait for the pipeline to open back up.
Questions? Borden.
Could you provide a little more backstory on why the pipeline's been shut down?
Mr. Kirkwood's going to testify to that.
Okay.
Any other questions? Ms. Davis?
What is the ownership of PEMC, i.e. does Wesco have any ownership in PEMC?
No, we do not. If you'll look at the map that's on the screen, I'll detail the ownership. The Kirkwood and its partners own the interest in the Cane Creek unit and the Dead Horse lateral to our Blue Hills gas plant. That is the extent of our ownership in this area. We do not have any interest in the Greentown pipeline that connects us to Northwest Pipeline. We pay a tariff fee to transport our gas, but we do not have any ownership interest in that, in the Greentown pipeline.
So you can get gas to the Blue Hills gas plant, but you can't get it out of there, is what you're saying?
Yes, that's correct. Our gas goes to the Blue Hills gas plant and can be processed, but the outlet from that plant is shut down.
How far is it from the Blue Hills gas plant to Northwest Pipeline?
As the map shows, it appears it's only about 6 miles, but what really is the case is the Greentown pipeline takes our gas approximately 6 miles to the highway US 191, and then their pipeline parallels US Highway 191 on the east side, approximately another 6 miles, where they interconnect in with Northwest Pipeline. So a total of approximately 12 miles.
And what are the volumes? We're talking about flaring?
Well, again, Mr. Kirkwood will testify to that,
Okay.
but the request is 400 MCF a day.
Any other questions? Seeing none, call your next witness.
Okay. And just for the record, the reference of the map is Exhibit 3, which Mr. Kirkwood was going to testify on as well. Mr. Kirkwood, would you please state your name and business address for the record?
Tom Kirkwood, production engineer at Wesco Operating, 120 South Durban, Casper, Wyoming.
Okay, and what is your current position with Wesco?
I'm a production petroleum engineer.
And you have supervision over the Cane Creek area?
Yes.
Okay. Okay, now referring to Exhibit 3, which is on the screen for the board. Was this prepared by you or Wesco personnel with your input and review?
Yes.
Okay, and again, would you just please outline for the board what this shows?
It shows our gathering line, which we call the Dead Horse lateral pipeline collecting from the Cane Creek unit, flows up to our Blue Hills gas plant where there's a sales meter. We sail down the Pacific Energy and Mining's line, and it flows down into Northwest line down to the southeast.
Okay, and what is the relationship between Wesco and does Wesco own the plant or does it just operate the plant?
Wesco operates the plant for Kirkwood Oil and Gas and Nerd Gas Company are the owners in of the plant and unit and all the associated equipment.
Okay, and what exactly happens at the plant?
At the plant, we process high BTU gas. Y-grade NGLs are pulled out and they're sold and trucked off. And then the residual gas is supposed to be sold at the outlet of it.
Okay, and could you, for the record, who operates the Greentown pipeline?
Right now, it's there's two companies. It's Pacific Energy and Mining and Dead Horse. They kind of tried to change operatorship of it, and I don't 100% know where that stands.
All right, and when was what was the status of the pipeline? When did it have to shut down? When was the gas not flowing from your plant any further?
On June 10th of 2019.
All right, could you go into detail a little bit exactly what happened at that point and what Wesco's doing with the plant and the gas right now?
So we'd known about this from beforehand. The Division of Public Utilities had provided us with a copy of this. We knew it was to be shut down on the 10th of June. We went out and manually turned it off so we wouldn't have risk damage to our plant. or a malfunction of an ESD or anything of that nature. The following day, inspectors from the DPU arrived at the plant to ensure that there was no gas flowing from the plant. Subsequently, a lock had been placed on a valve downstream of our plant. When allocated back, we talked to the BLM and the division about it, and when allocated back to the gas back to the individual wells based upon production, we were under the 1,800 MCF per day per well. However, in August, we reworked a well. There was some salt buildup around a fish, and it increased the production on that well which brought the allocated values to between 70 and 80 MCF per day. At which point, and it also the additional gas allocated the fuel use at the plant increased the rate of the King Creek 12-1 well to roughly 60.361 MCF per day.
All right, let me back up here. You said a lock was placed on around June 10th. Do you know who placed that lock on the valve?
I don't know whose lock it was. It was determined it was seen at a later date, and I asked my field guy. He didn't know when it showed up. It was just noted at a later date in the subsequent to the plant being turned to flare.
Hey, at what point, you indicate the division was notified. Was the division of BLM notified of all these events at that time?
They were notified that we were going to be going to flare, and we talked to them about the allocation process of it, and had agreed to that for the 60 MCF per day per well.
Okay. What is the status of the Public Service Commission situation? They haven't ordered resumption yet of the pipeline, have they?
No, they have not. Nothing's changed on that. And like Fred said, there's a hearing next week. I know they had a hearing a couple months ago, working towards progress early on. Talking to Pacific, it sounded like it was going to be resolved relatively quickly, but kind of stopped indicating that, and then we had the increase in there, and we contacted the division about it, and that's how we got to where we are now on it. Currently, off the plant, we are flaring about 221 MCF per day. The rest of it's used from the inlet gases, resulting in Y-grade NGLs, or plant fuel, or fuel for the transmission line to get the gas to the plant, and it's currently being flared in an engineered flare with a maximum capacity of 9 million cubic feet per day.
All right, let's back up for a second here. At some point, did you get some direction from the division as to what to do, given the fact that the Public Service Commission hasn't allowed resumption of operations?
Correct. Yes. In November, they had due to the increase, they had told us to file for a request for agency action.
So the division then directed you to do that. Is that correct?
Correct.
Okay. Now on the flare, you've indicated the statistics of it. Bottom line is how efficient is the flare? I mean, is it burning off all the residual gas?
It's an engineered flare for it. For as far as efficiencies, I couldn't find whether it was 99 or what it was, but the design specs for it say it's capable of combustion of all components of the gas, and they had the gas analysis of the gas that would be flared in it.
Where's the location of the flare in relation to the plant?
It's about 100 feet northeast of the plant in an area kept free of vegetation. There's no businesses or residences located within 1 mile of the flare.
Okay, I'm now going to show you what has been marked as Exhibit D. It's a 2-page exhibit. This was attached to the verified request for agency action. Could you please explain to the board what Exhibit D shows?
Exhibit D is the inlet of gas coming into the plant. As you can see down here, it's got a very high BTU factor on it. And then the second page is what's being flared after we pull out the propane and it's got the lower B2 factor of around 1,200, and as you can see, the majority of the propanes and heaviers have been stripped out from the gas and are being trucked off and sold.
Okay, is there, again, just for confirmation, the Dead Horse lateral gas gathering system from the unit to the plant, your predecessors constructed that to deal with the residual gas from the unit?
Correct, yes. The plant and the Dead Horse lateral gathering system was constructed previously to our acquisition of the King Creek unit.
And that was a multi-million-dollar, I mean...
Correct, it was in the tens of millions of dollars.
I'd like to point out to the board at this point that if you recall, there were several flaring matters by Fidelity that for the wells during that time period for the construction of that pipeline and plant to deal with this residual gas, which the board granted at the time understanding that, and then finally got put into place. I'd ask that the board take judicial notice of those orders that were entered. It's the series of 196 causes, and in particular the 19644 order, which dealt with the unit-wide flaring until that was done. How much of the gas is used to operate plant operations?
About 150 MCF per day is used for fuel for the compressors to bring it from the field up, as well as to run the electrical in the burners and stuff at the plant.
Okay. Could you explain to the board why there's no other option other than flaring from the plant? I mean, could you choke back? Could you shut in the wells? What other options are there, viable options, or are there?
The choking back of the wells could increase. Well, it's going to cause economic issues, as well as you can have salt forming and falling out and creating bridges inside wells, also, if you were to choke some of them back, it hurts the wells that are over the 60 MCF per day. It would definitely basically make the whole field as such uneconomic, and could potentially damage equipment on surface from salt falling out, and equipment on surface, and damage the wellbore from salt inside the wellbore. We keep continual freshwater treatments on the wells to ensure that there's not damage while they're producing. But if you do freshwater treatments and don't produce it, the freshwater could get to the zone and cause swelling and additional issues in the formation as well.
And the economic standpoint, obviously, is you can continue to produce the oil and also strip off the NGLs and get revenue streams from that. Is that correct?
Correct. Yes, everything that we have ability to truck off and sell, we're selling.
Okay. And as far as the gas that's being flared, is royalty being paid on that, just for confirmation and following up Ms. Davis's question?
Correct. Royalty is being paid on the flared gas in accordance with the index-based option for federal non-arm lengths valuation regulations.
Okay, so from your standpoint as the operator of the plant and also as the petroleum engineer for these wells, is it your expert opinion that flaring must occur until the Public Service Commission allows the pipeline operations to resume?
Correct, yes.
Okay. That concludes my examination, Mr. Kirkwood.
Vision?
Okay, at first I'd like Mr. Doucette to be able to ask a few questions, and then I have a handful as well.
Proceed.
Yeah, Dustin Doucette for the division again. So currently, there are 18 wells that are going into the pipeline that are contributing, I guess, to the flared volumes currently. Is that correct?
Correct, yes.
And of those 18 wells, do you know how many are over the allowable amount allowed by Rule R649-3-20?
There's two of them. The King Creek Unit 36-1, which has been on the order of, after shrink and fuel, 70 to 80 MCF, and then the King Creek Unit 12-1, which is 60.3, was last month's average. We made 1,810 MCF.
And just to clarify, I think you had mentioned 60 MCF per day. But I think you also had mentioned 1,800 per day allowable.
Sorry,
but
yeah, per month, yeah.
But that's 1,800, the allowable is 1,800 per month per well, is that correct?
Per month per well, correct, yes.
Okay. So currently you only have 2 wells over that allowable amount. One of those is right at the edge, I guess, of being under that allowable amount.
Correct.
Are there any plans to drill any additional wells before you see this potentially getting cleared up, or?
So right now, we did just complete we're in the process of completing the 7-2 well. Results are varying. Right now, there's a significant amount of work that needs to be done before gas would be to the plant, probably on the order of 2-3 months. And that's if it turns around for us. Steve had said, currently we don't have any current plans to drill wells until the West Fertilizer EA is completed. We're running out of locations down in the southeast area.
And I guess just as far as any workovers or recompletions, do you have any plans for that you know of?
We do have plans to possibly put a stimulation on the 12-2 well. Right now, based upon past stimulations that have been done, the majority of them will not lead to an increase on the magnitude of 1,800 MCF per month on that, and it's kind of been backburnered. So I would say that there's a potential for it, but there's currently no current AFEs out to do this work.
So you don't see significant increase in the current flared amount?
No, it would be, if anything, it would be decreased just due to natural decline on it. The gas rate on the 36.1 has actually been falling off a little bit over the last month and a half, current rate. So, and the problem with this is a lot of these values are into the month because you're at the tailgate of your gas plant, so your allocations can't be done until the first of the following month. So it's really hard to 100% judge. But just with natural decline, I would say that the chances of growing is slim, and the better chances that you would be smaller.
I guess that kind of goes into my one final question. What are the benefits of flaring at the plant versus flaring at the individual well sites?
The main benefit is you're going to get the value for your Y grade out of it. It's not enough to cover the cost of the plant, but the plant cost is fixed if you still have the people and the manpower and all that, and the rental equipment still out there. So it is increasing that. It is also a little bit further out of the main area from the field too.
You have view shed issues on the Dead Horse Point
Correct.
For flaring and
Correct.
et cetera?
Yes. Yep.
Okay, that's all the questions I have. Thanks.
Mr. Kissinger.
Thank you. So we've been talking about allowing the gas processing plant to flare, but ultimately all the gas that's getting flared from that flare can be traced back to individual wells.
Correct. Yes.
And so is there a limit for a gas processing plant in terms of flaring by rule?
Yeah, I'll answer that legally. The regulations at 3-20 sub 8 and 20-9 are the regulations that deal with the gas plant, and it says there is no flaring unless it's a very temporary nature or if it's going to be an extended period of time as the division directs. And as was testified, the division directed to come to the board and ask for relief here.
Okay, so effectively the limit would be 0.
Correct.
Shall not flare. Okay. Are there any other entities that regulate this facility, maybe like the Utah Division of Air Quality?
We currently do have a permit with the DAQ regarding the plant, and all the equipment that is out there is approved through the permit.
And so do you know how the flaring will affect your air quality permit?
The air quality permit doesn't overly have volume or a flaring limitation. It says that there's a flare there that can be used for and gives a list of emergencies, downtime, blowdown of equipment for repairs, and stuff of that nature.
And so would you consider this to be an emergency or downtime?
I would consider this to be more of an emergency type basis we were no longer allowed to flow through the existing pipe that was operated by a third party.
Okay. And in terms of ways to reduce the flaring, you testify that choking back these wells would have an effect on its production. Could you be more specific? I mean, is there a way to limit it, just incrementally, or is it an all or nothing?
Well, there's a way to limit it incrementally, but as I was talking for the with the 12-2 is that the cost kind of cost wise for the field costs so many net barrels to produce it. You start pulling, you turn off some of our larger wells, the 36-1, then your costs are associated to everything else goes down, and your whole field as a whole can turn negative. That being said, also the majority of the gas is coming from a lot of those wells only make on the order of 5 to 10 MCF per day inlet to the at the sales point of it. So it would take a lot of the marginal mediocre wells to be shut in to drop it down, and then or swing your allocation amount over. And then the 36-1 is a good example of how that salt can damage it. That was what we were fishing out due to salt falling out from a well, and had spent a series of months to get to the well turned back to where it would produce.
Okay, so in essence, the economic waste that would occur if you were to shut in these wells was greater than the resource waste that occurs when flaring this gas?
Well, the point is if you do turn back these wells, then it gets to the point where none of them are capable of producing it at paying qualities unless you go through and do a very significant amount of reduction of operating costs through personnel and equipment and stuff of that nature as well. But
okay. And just so I'm clear, in the notice it says you reworked the 36-1 well due to a fish in the hole, and that means that there was salt buildup that you needed to essentially remove. That's
correct. There's for the completion process of these wells, they perforate them with a very long tubing conveyed perforating gun, and then you produce the well through that well. That hadn't been removed, and the salt had built up around that and plugged off the majority of the lateral of the well, and due to casing size restrictions and tools equipment, it very, very difficult to get back.
okay. And this question might show some of my ignorance, but you're able to strip out the Y-grade NGLs and truck those off-site, but a similar process for flared gas would be, you'd have to liquefy that natural gas and then truck it off-site. Is that essentially it?
Yeah, correct. They do make compressed, where you can compress your gas onto a truck. They can hold on I think they can hold on the order of about 300 MCF, but you need very specialized high pressure compressors, and that's about a day and a half of production. So you'd be doing a lot of quite a bit of trucking too.
Okay. I believe that's all the questions I have at this time.
Members? Start at the far left. Mr. Borden.
I'm going to have two questions.
Closer to the mic.
Yes, okay. Yeah. I think I'd heard you say that you were flaring right now 220 MCF a day?
September average was 221 MCF a day.
And am I correct, though, the request is to flare up to 400 MCF a day?
Well, I just wanted to have a little leeway on either side. Also on a daily rate, they can swing high. A day can be high, a day can be low. But just what I didn't want to do is put 225 and have an issue on the high side.
But I assume on a monthly average, you probably would be unlikely to go above 250 or something like that. Is that correct?
I would say so. The only problem I have is that I've got one since the work over. I have 1 month of data for average flared volumes. I should be getting another one here shortly. In which case that could you could shed more light on the consistency of that flared volume. It also runs in the consistency of your how your generators swing for your fuel, temperatures. If you need more temperature to run certain parts of the plant, it could swing as regards to that too.
How much of the value of the delivered gas to the gas plant is actually being recovered right now with the heavier hydrocarbons that you are pulling out?
I would have to double check. I want to say we were on the order of probably. I don't want to lie to you on that. I want to say we're on the order of like 800 barrels of Y-grade a month, and that sells for anywhere from 25 to 40% in IMEX. But I can get that information really quickly. I don't have it handy right now.
And last question, I still don't understand what's wrong with the pipeline that's causing all these issues.
The Public Service Commission had shut them down for a number of violations, and then their non-response to violation notices and repairs had led them to the point where they were going to shut the line in.
If I can add to that, part of the problem is that the pipeline operators have been challenging the jurisdiction of the Public Service Commission as well. And there's a lot of issues. The orders that were attached to the request pretty much spell out everything that the PSC, why they shut them down. But part of the reason that it hasn't been resolved is there's been numerous challenges made along the line by the pipeline operator.
So it's more of a management issue than a physical issue with the line, huh?
I think it's a lot of paperwork type things and some field work. I'm not 100% sure on that side, but I think the majority of it's that.
Thank you.
Ms. Davis.
You mentioned to Thomas Kessinger that you could truck it out. We have not seen any economic analysis of pressing it and trucking it out. Why not?
I have not done any. It's the compressors alone to do that are going to be in the $20,000-$30,000 a month range, and the value is on the order of $400 or $500 a day, $600 a day type rate. I hadn't thought that to be an option. There's not very many places to offload it. I know the only reason I know much about it is one of my supervisors used to do it for drilling rig fuels up in North Dakota, but I know it's definitely not a common option that I've seen.
Still, if it's that stark, I would like to see the economic analysis. of what it would cost to compress it and truck it, especially if the PEMC pipeline is never going to go back up. We do not know when or if that pipeline's ever going back up and what you're going to do about long-term solutions to this problem.
Well, I guess we have been in talks trying to figure out a way that we can own their line, take it over, buy it to where we can have control of the gas to there. But it's something I'm more than happy to look into the options.
I would like to see analysis of the options, considering there's an interstate pipeline 6 miles away.
Okay.
Questions on the right?
So is this pipeline that's been suspended, is it just your gas, or is there quite a bit of other gas going through it? Pretty good size.
They have their well flows into it. I think it's only on the order of 100 or so MCF a day,
Okay.
but we were the majority of the gas in the line.
Okay. And what's your prospects right now of it? I mean, what are they telling you? Are they working hard on it, or are they basically
Gordon, your
just,
mic's not working very well. Yeah.
Sorry. Are they saying they're going to get it back going, or they're just going to legally fight with?
I mean, when I've been talking to them, they've always seemed like it was not. They were just going to walk away and abandon and tear up the line. That being said, I know Fred talked to them and the Public Service Commission, and they thought 3 to 6 months is what she was thinking.
That was, the Division of Public Utilities.
Yeah.
So if you were to buy the line from them or get it from them, how tough would it be to get it back in compliance? Do you know?
I would imagine it wouldn't be very difficult.
Okay, so were there defects in the line, or was it just compliance questions?
To my knowledge, it's nothing mechanically wrong with the line. Okay. It's just.
Board members, can I make a suggestion? We have a couple of more matters, 2 or 3 more matters to hear. I'd like to have a meeting with council and the board in chambers. I don't know if this room is available, but could we do that for purposes of this matter? You can ask. Yes, of course.
Just a quick question. On the air quality permit, are you...
Mic's not on, or it's not catching you.
On the air quality permit, are you required to notify the Division of Air Quality that you're going to be flaring at the gas plant?
I'd have to double check on that.
Okay, thank you.
Okay, we're going to go in chambers. Lee? Reporter, you ready? We're back on the record. I think we were with the division at this time. We'll go back to you.
Yeah, the division doesn't have any further questions.
Board members, I know you have a lot of questions. I'd like to suggest that we present an interim order with a resolution that I'm going to ask council to develop. The resolution would be to the Utah Public Service Commission with sufficient facts and legal background on the duties of this board, particularly dealing with waste and our rules, and a discussion about decommissioning the line. I'll let council work that out. But the proposal, I think, that would help at this time, and I'll let you comment on this. This is not a final decision, but a proposal would be that we have an interim order prepared by Mr. McDonald that allows flaring at the 400 MCF per day until the day after. This interim order would go to a day after the next board hearing. And I'll let you comment on that, council.
And at that board hearing, the board is seeking some testimony and exhibits on economics. Is that understanding?
Yes.
Okay.
The options that are out there and why those economics on why those options that the board could look at. The board wants that on the record.
All right.
Hang on just 1 second. Council?
I think that is a good way of going about the situation. Approving this on an interim basis and then getting the economics in the record will help make a more informed decision. So I support that proposal.
Now to the board. Susan Davis.
To be clear, Mr. Kessinger put forward an alternative, which was trucking, but I am sure there are other alternatives. I do not know what they are. For instance, putting on a portable electric generator and selling it as electricity as opposed to trying to transport the gas. I don't know if that's economic. That's why we want you to look at it. But I just wanted to say, don't limit your exploration of what to do with this gas to trucking it.
Board wants that on the record. We want to know what the options are under current technology and why, whether any of those are economic and why they're not economic. Is that pretty clear?
Yep.
Hey, board members, have you understand? So a motion is in order to continue the flaring on an interim basis under an interim order for a period of time from now until one day after the next board hearing in January, subject to the ESCO coming back in, the petitioner coming back in and providing additional economic analysis of options. That can be done by remote testimony. You don't have to come before don't have to come here. And it may be that once we look at that, or we'll be able to do further. The other part of the motion would be, it's a two-part motion, is that we would have council prepare a resolution that some of the things we're seeing are difficult, if not against state law.
Mr. Chairman, if I could also, just for bookkeeping purposes, get the exhibits admitted?
Yes, of course.
Okay, that would be exhibits A through D and Z, and exhibits 1 through 3.
Council, for the division?
No objections.
Board members? They're so admitted. Okay. Mr. McDonald, you'll prepare that order, and with council, you'll prepare the resolution? Wait
Yes.
a minute, we haven't had a vote on it.
Yeah, I think it was a proposal that you were going to say I need a formal.
I made that proposal. Is there a motion adopting that proposal?
Do we have a moment for discussion?
Yeah, we will after the motion seconded.
Moved.
So moved. Is there a second? Second. Okay. Further comments on that motion?
Just one, that the resolution that's prepared by council will include a discussion or a emphasis on the fact that we see this as waste, and that the PSC move forward to address that waste in an expeditious manner.
Yes, that's, I think that. Okay, council, do you feel like you understand what the motion is? Okay. So any more comments? The motion before you, I've previously stated. All in favor, say aye. Aye. Any opposed? Let the record show that was unanimous. We hope that's helpful to Wesco. Now, we're going to go to the next item on the agenda. Give me a second to get there.
Spencer K. Barton, Altamont.
Okay, we are at the agenda item number 4, docket number 2019-025, cause number 139-169, in the matter of the request of Altamont Energy Operating, LLC. How much time will you need to get ready?
If I can get my password right, not too long.
Just to make you aware that we are at a time crunch, so if there is a part of this that you could move quickly, please let us know.
Certainly, Chairman Gill, and if the board would like, I can do similar to what Mr. McDonald did and proffer, just for background, so the board can have an informed decision it's making. Altamont was here.
Not close enough to the mic.
Oh, I apologize. I told you. I told him everyone gets told to get closer to the mic every once in a while. So, Altamont was here in July on essentially the same request for 2560s. These are just the two sections next door that we're trying to include into this. So to the extent the board feels that proffer of testimony would be appropriate, I'm happy to do that. If not, we will just use our auctioneer's voice and try and get through some of this as quickly as we can.
Just a request of the board, in terms of however this is decided, the board prefers the term drilling unit boundary well, not section line well. We believe that's an incorrect, a misleading statement, so just make a note of that, please. Drilling unit boundary well.
Okay, will do.
And if you slip and say section line well, or there will be no demerits just as long as the order says it.
Risk compensation award, right? Drilling unit boundary well. Would the board like me to proffer or just proceed as?
I think the board would like you to proffer unless there's objection to from the division.
No objection from the division.
Okay, we're sorry to have you come all this way for a proffer, but it sure expedites matters. Board members, any objection to a proffer? Okay, let's proceed.
Okay, thank you. Mr. Chairman, first
You need to have the witnesses sworn, and then to the extent that you're going to qualify in them, anyone that's for the first time, please let us know.
I will. Thank you, Your Honor. Mitch Mayo, on behalf of Altamont Energy Operating, LLC, and we're here today on the request for agency action to establish a 2560-acre drilling unit. With me today are three witnesses: John Oburn, and please stand up if you would, Deb Ryan, who is a petroleum reservoir engineer, and Rick Kopp, who is a geologist and the vice president of geoscience. Mr. Oburn will be testifying as a land witness today, just a fact witness. Ms. Ryan and Mr. Kopp both were testified as expert witnesses in Altamont's cause in July, in cause number 139-165. And so with presumed stipulation, I'd like to admit them as experts in this matter as well for their respective fields: geoscience for Mr. Kopp and reservoir engineering for Ms. Ryan.
No objection.
Board members, any objection? Okay, proceed.
If the court reporter would swear the witnesses in at this time, please stand.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Now, one quick matter I wanted to address before I go through the proffer. Thank you. One quick matter to address. We filed a motion for a partial continuance last week. We noticed everyone on the mailing list, including the BIA, at their last known address of record. However, we did not mail what we typically mail, which is courtesy copies to the local BIA office in Fort Duchesne and to the local BLM office. We did not receive a comment letter from the BLM, which is somewhat unusual, and that alerted us to this mistake. We have corrected that, and based on the board's order, it's my understanding that a portion of these lands will essentially be continued, depending on the outcome of this hearing, to the January board hearing, where if the BLM and BIA have any input they'd like to give, I will be back, and the witnesses will come back if there's opposition from the BLM or BIA.
Board members, do you understand what we're doing here?
Okay.
Okay. Any objection to that, board members? Okay, we'll go under that order.
Thank you, Mr. Chairman. Mr. Oburn here is a contract landman for Altamont. He has been for a number of years, and he would testify today that, and maybe what I'll do is similar to the last hearing by Mr. McDonald, go through each exhibit and essentially lay out the testimony that would have been there so we can discuss the exhibits as well. Exhibit A, Mr. Oburn would have testified that these 4 sections are the 4 sections at issue, sections 1, 2, 11, and 12 in Township 2 South, 2 West, just northwest of the town of Roosevelt. Mr. Oburn would have testified that we provided notice to everyone within those 4 sections and everyone within a half-mile buffer of those sections, exclusive of the parties that we identified in the previous discussion. As the board will see, Mr. Oburn would have testified that it is primarily fee land. There is a little bit of sitla land and 2 parcels of tribal interests as well in these sections. Currently, these lands are spaced at for 1280 drilling. Sections 1 and 12 are spaced under an order that Altamont secured in March of this year in cause 139-163, and sections 2 and 11 are spaced for 1280 wells under order 139-154, which was done by Crescent Point, I believe, a couple years ago. However, for the board's notice, Mr. Oburn would have testified that the spacing granted in each of those causes is functionally identical. Same setbacks, same number of wells, etc. Mr. Oburn would have testified that these lands identified in yellow are the only lands in this area that are spaced currently for 2560 drilling unit boundary wells. As you can see, the lands under consideration today, 1, 2, 11, and 12, are essentially just a westward continuation of that prior cause, and Mr. Oburn would have testified to that fact. This map just helps depict. The blue dashed line is what Altamont was here before the board in July to discuss and what the board granted as 2560 section line wells. Drilling unit boundary wells. And today the section in red. Mr. Oburn would have testified that under the current spacing in cause 139-163 relative to these 2 sections and cause 139-154 relevant to these 2, that there is at least an 1,120 foot wide channel of resources that have yet to be developed. In actuality, the 2 closest wells are this well here, the Galloway 1312, and that's about 700 feet away from the section line, and over here the Galloway 4411, which is about 670. So actually the space between wells that we're targeting with this request is nearly a quarter mile. And this should appear very familiar to the board. Mr. Oburn would testify that this is the spacing that we are requesting in this hearing, essentially one 2560 acre unit to be developed. The setbacks that we are proposing are 330-foot heel-toe setbacks, so from the north and south boundaries, and that the well has to be within 100 feet of the center line of this boundary line between the sections, and that there is 100-foot stacked interwell setbacks between the 3 wells that we're requesting along this section line. Mr. Oberon would have testified that the request we're making today is an exact replica, if you will, of the request made in July, and would you agree with that testimony?
I agree. Oh, I agree.
Thank you. Any questions for Mr. Oberon from the board?
Let's go to the division first. Division, any questions?
I just have one question, and I don't know if Mr. Doucette has anything to follow. I guess the concern the division has, which I think is addressed in the request, I just wanted to get it clear for the record, is that the 2 1280s are held by production prior to this drilling unit boundary well being established, and have those 1280s been produced yet, or what the plan is going forward for producing this?
The 1280 encompassing sections 1 and 12 is held by production at this time. There are multiple wells in those sections. Section 11 has a well in it that's being produced by Altamont. Section 2 does not. And so a horizontal well to hold that 1280 would need to be drilled first before a drilling unit boundary well could be drilled.
Yeah, that's great. That's all I have. Do you have anything, Mr.? That's all from the division.
One quick point of clarification. Mr. Oberon's correct that both sections 1 and 12 are held by production in the kind of technical standard industry term. They are not held by a horizontal well as the board has required in these drilling unit boundary wells. And so in actuality, Altamont will be doing with this spacing unit the same as it will be doing with its prior spacing units, which is drilling a horizontal well in 1 and 12, a horizontal well in 2 and 11, and then a well down the middle, all kind of at the same time.
That's great. That's what we were concerned with.
Thank you.
Board members, any questions of the board? Mr.
So
Moon.
the plan is to do the third well being this drilling unit boundary well.
Yes.
Okay, from the same pad?
Yes.
3 from the same pad?
Yes.
Okay. And the motivation for that is that where your best geology is, or?
That would be a question best asked to Rick Kopp, who's set to testify on the geology in this matter.
Okay. Operationally, what I understand to be, drilling rigs are very large pieces of equipment, and completion rigs, which they bring on after the well has been drilled to depth, are significantly smaller. And so it's my understanding, in an effort to minimize surface impact with the well pad, that the best way operationally to do it is to bring in a drilling rig.
Yeah, that's understood. That's understood.
Okay.
It's just that we're putting that first well pad on the drilling unit boundary and actually drilling those first 3 wells.
Well, the drilling pad may not necessarily be right on the boundary, for what it's worth. With directional drilling, they can do it.
Understood. Just pointing out that is a little bit unprecedented. Usually, first wells are drilled within the drilling units. Well, they will be, but you're doing it at the same time. So anyway, that's good to know.
Okay. Mr. Oberg, do you agree with that? That would have been your testimony had you testified?
Yes, I do.
And call your next witness.
Thank you, Mr. Gill. I'd like to call Rick Kopp. And I'd like to remind the board that he is qualified as an expert witness in geoscience for this hearing. I am not, but I will proffer what Mr. Kopp would have testified to.
Is that okay with the division?
Yeah, no objection on that.
Board members, is that all right with you? Proceed.
Thank you. Mr. Kopp would have testified that we tried desperately to make these exhibits larger at the board's request at the last hearing so that they were more legible. It is incredibly difficult to do. If the board would like us to do paper copies in the future so that we can blow them up, we are happy to do that. This is
Decide that at the end of the hearing.
Thank you. This is a type well. As we saw in this slide, the Galloway 1312 is located right here in the southwest quarter of Section 12. And the Galloway well, the 1312, was used for the type well. And this shows, Mr. Kopp would have testified, the gamma ray track and the resistivity track, and those help identify where the targets are. The board is probably intimately familiar with type wells by now, and this just shows what are kind of the typical productive intervals in this area. Mr. Kopp would have testified that this is the delineation of the proposed spaced area under the request for agency action. It is this red box. This map is really cluttered and hard to read, but the reason is to show the limited development that is in this area as it comes to horizontal wells. The green dots are vertical wells. Mr. Kopp would have testified the green lines are producing horizontal wells or drilled horizontal wells, and the red lines are permitted horizontal wells. As you can see in the 4 sections at issue today, there are only some vertical wells, and a majority of those, or a good number of those, have been plugged and abandoned or are shut in. Mr. Kopp would have testified today, if asked, that typically we do a cross-section in one slide, but to address the board's concerns, we tried to break it up into multiple slides. This shows the 2 wells that were used for this cross-sectional analysis, the Galloway 4411, which is down in the southeast corner of section 11, and the Galloway 1312, which is in the southwest of section 12. On this next slide, we broke it up into from deep to shallow. So this first slide deals with essentially the lower formations, and Mr. Kopp would have testified that, as you can see, there are some identified pay zones in yellow, orange, pink, and that they are continuous throughout this requested area. As we go shallower and we move up in the formations toward the surface, you can see that the continuity stays, that there are several other additional pay zones and even more additional pay zones higher up that Altamont believes it can target. And finally, Mr. Kopp would have testified today that this is an illustration of the spacing that has been permitted in this by this board for these lands. To be clear, every well that is depicted on here, these blue dots represent wells. In cause 139-154, the board authorized Crescent Point at the time to drill 12 wells in these sections. In cause 139-163, the board authorized Altamont to do the same, 12 wells in these sections. And in cause 139-165, just this summer, the board allowed Altamont to put in these 3 stacked horizontal drilling unit boundary wells. So the only 3 wells depicted on this exhibit that have yet to be approved by the board are these 3 drilling unit boundary wells here. Mr. Kopp, would you agree that that would have been your testimony here today?
Yes, I agree.
Is there anything you'd like to add to that?
No.
Okay.
Vision, any questions?
No questions from the division at this time. Thank you.
Board members?
Really quick, why weren't these included in your 139-165?
Which exhibit?
Well, just section 2 and 11.
Oh, very good question. Honestly, it was a title snafu. I think Altamont was under the impression that it didn't have as much interest in sections 2 and 11, and it wasn't necessarily worth it as they've looked into it and had some of those titles.
Kind of needed to complete your 2560s. Yeah.
Well, the problem with those drilling unit boundary wells is there's always going to be outside boundaries that aren't included, and I think, if this pans out and proves out the way Altamont hopes, ideally there will be expansion down the road to continue. So, any further questions for Mr. Kopp?
Any other questions? Seeing none, call your next witness.
Thank you. Thank you. I'd like to call Ms. Ryan, and I'd like to remind the board and the division that Ms. Ryan has been qualified as an expert in petroleum reservoir engineering for this cause. If Ms. Ryan were to testify today, she would say that this exhibit depicts the offset wells, which were, you know what, Ms. Ryan is incredibly succinct. I will let her do this because she will do it faster and better than I will. How do you feel about that?
I'm happy to do that. Yeah, so Exhibit L here shows the offset wells from the application area here. The application area is shown in red by the boundary, and the original both 1280 spacing and 2560 spacing from cores 139, 163 for the 1280s and 139, 165 for the 2560s is shown in grey. There are three colours depicted for the offset wells. The blue dots are the offset Wasatch wells, so the deeper yellow wax Wasatch. The pink dots are the Uteland Butte, sort of that middle formation, also yellow wax offset horizontal wells. And down to the southeast, there's two shallow Green River wells that have also been drilled, which are black wax wells, and we will talk about the implication of what the difference between the yellow and black wax is. When we look at the type curves for those three groupings of wells, there's two Exhibit M's, so the first of 1 and 2. So the Uteland Butte Green River yellow wax, so the middle formation, there's 11 offset wells that are from 1.5 mile to 2.5 mile wells. What we're looking at for all three plots, for the Uteland Butte, the Wasatch, and then on the subsequent slide for the shallow Green River, is a plot of the offset oil wells. The offset oil production is shown by the grey lines. That Mitch is pointing to. This is the offset production for the Uteland Butte wells. The blue line that runs through those is the average production. And the green line is the type curve that has been differentiated and delineated from that offset production data. The right-hand axes on each of these plots is the well count. So you can see at the very base of the plot there is a well count over time, where initially in the Uteland Butte Green River we have 11 wells, and that declines depending on how much production history we have. When we're fitting type curves to these wells, we want to make sure we use as many wells as possible so that we don't bring in any bias to any of these forecasts. So the green line is an early extrapolation of that production history. For the Uteland Butte, we're looking at an initial rate of about 30,000 barrels per month. For the Wasatch, we see about 40,000 barrels per month when we look at the offset wells. And then when we look at the Castle Peak Green River Black Wax, we're seeing at the moment there is only 2 wells. They only have 7 months of production history in them. The shallow black wax has a much lower, what we call gas oil ratio. It's about 500 standard cubic feet per standard stock tank barrel, compared to the yellow wax, which is 1,000. So these wells have lower pressure, lower energy to get the oil out. So we see a lower rate on these ones, about 20,000 barrels, which impacts the EUR. But there is only 2 offset wells when we look at that. So when we take our type curves and we apply our economics, for our drilling capital for our Uteland Butte and Wasatch, we've assumed $11 million per well, both drilling and completion capital. This is from AFEs, both from offset operators and that Altamont is putting together as part of their development plan. Our operating expenses are assumed to be $15,000 per well per month. The oil prices we've used in this current economic scenario, net to Altamont, are $49.50 per barrel of oil, and for gas, $1.53 per 1,000 standard cubic feet of gas. Severance taxes and ad valorem have been assumed at 3.5% and 1.04% respectively, based on historical LOS information. For our Uteland Butte yellow wax, we've assumed, for all the type curves, we assumed a 100% working interest, 85% net revenue interest for the economics. For our Uteland Butte, using the economic inputs that I just went through and the type curves from the previous slide, we see just under 1 million barrels of oil and just under 1 BCF of gas for both our Uteland Butte and Wasatch wells, with a before federal income taxes, cumulative discounted cash flow at 10%. For our Uteland Butte, we see $7.5 million on a 10% discount factor, which is a 2.87 year payout and a 37.3 rate of return. For the Wasatch, we see just under $9 million on the before federal income tax cumulative cash flow, payout of 2 years, and a rate of return of 49.5, given that higher initial rate. And then for our lower GOR, or lower gas oil ratio wells in the shallow Green River, again, lower initial rate, we still see just over 600,000 barrels of economic oil from these wells, but that gas rate is half because of the lower GOR, with 334 million cubic feet of gas, cumulative discounted cash flow of 1.6 million, slightly longer payout time, 7.12 years, and a rate of return of 15.7%. The only other difference with our Castle Peak is because this is a little bit shallower, we have a $10.5 million capital instead of 11 because of the lower drilling costs for the shallower wells. When we look then at the application area for the spacing, from a volumetric point of view, when we look at all 4 sections, the net pay, the porosity, and the water saturation, in that section, we have just over 400 million barrels of in-place oil. As was alluded to, there has been some vertical production in this section. The map that we are looking at is a cumulative history map. The bubbles on the map are actually colored versus size, where the red colors show lower volumes, up to about 50,000, but there is some zero numbers in there, and then going to purple, which is over 1 million. Within the application area, there has been just under 4 million barrels of oil produced. As indicated, there's 2 Galloway wells that Altamont operates that have some ongoing forecasts and therefore reserves associated with them. But the combined vertical estimated ultimate recovery, EUR, is 4.14 million barrels from the vertical development. When we look then at the drainage based on the horizontal development, as was stated earlier, both section 2 and 11 and 1 and 12 have 12 wells per 1280. And then based on Exhibit L from Mr. Kopp, we have on the 2560 between section 1, 12, 6, and 7, 3 wells already permitted. So half of that will drain sections 1 and 12. And then with the additional 3 wells, if granted, will drain a full well. So the 2560 spacing is sort of 1.5 times for 3 wells per spacing, but that gives us a total horizontal EUR, if all of the wells that are permitted are developed, of 28 million. When we combine the vertical cumulative production and the horizontal cumulative production, the 2560 section is estimated to produce 32.9 million barrels of oil, which relates to an 8% recovery factor, which we believe is appropriate for this kind of reservoir and this kind of development.
And one point of clarification, I think Ms. Ryan in her haste used a term colloquially. She said they were permitted. I think what she meant was they are allowed.
They're allowed.
The board has spaced them. They have not yet been permitted, but I believe permits are in the process for that, just to
Permits
clarify.
are, yeah, pending but not approved, yes. My bad.
Division?
No questions from the division.
Board members, any questions for this witness? Mr. Moon?
So if I heard you right, there has already been over 4 million barrels of production from these 4 sections from vertical development.
That's correct.
Okay, that's good.
Yeah, and I mean, you can see even just to the north, there's 2 purple wells in section 35 and 36 that have cumed over 1 million barrels each just with those 2 wells. So some of the early vertical wells through this area have produced large volumes.
So why haven't there been other vertical wells drilled in this area for quite a while? Is the idea that they've drained a lot of that down that drill bore, or?
Well, I mean, when we look at the vertical drainage of a lot of this, a lot of the vertical spacing that underpins each section is 4 wells per section. So section 11 in this application area already has its maximum well count, and there would only be a couple more locations anyway from a vertical point of view. And given the total volume, there's over 400 million barrels of oil in the section, and yet we only drained 4 million. So that's only 1%. So there's a lot of undrained oil that can be accessed with the horizontal development that has not been drained by the vertical production, even though those numbers are as big as they are. So, yeah.
Other questions? Yes, Mr. Church.
On your capital cost economics, is that estimated for what the first well would be, or does that take into account the savings that you'd have drilling multiple wells from one pad, or also your completion costs?
So the capital costs are AFEs for the first, I guess, tranche of wells. So we're assuming that we've got, I think we've got 6 wells pending permit at the moment, and so it's the original AFEs for those first wells. I would agree, as we drill up all of the area, we would see cost improvement on that. We've already seen in the basin with offset operators and AFEs that Altamont has participated in that drill cost has come down from 12 million to 11 million already, and we've taken that into account. If you compare back to the July hearing, we assumed $12 million, but we're already seeing some cost improvement in the basin because of learning curves and drilling efficiencies. So.
Other questions? Okay. Have you any more witnesses?
I do not have any more witnesses. One thing I would like to do for the record, though.
Closer to the mic.
I apologize. One thing for the record, I did not have the witnesses lay foundation for the exhibits. So if I could, exhibits A through G were prepared by Mr. Oburn or under his direction or supervision. Exhibits H through K were prepared by Mr. Kopp or under his direction or supervision. And exhibits L through O by Miss Ryan. If I could have the witnesses confirm that for the record.
That's correct.
Thank you.
Division, any objection to that?
No objection.
Okay. So we'll note that.
Okay. You know, if the board would like me to sum, I'm happy to do that.
Let's go to the division first with its presentation, and then we'll go back to you for summation and offering the exhibits and such.
Thank you.
The division will waive its case in chief, and we'd just like to express our support for the request as submitted.
Board members, any questions of the division or anything else? Yeah, Mr. Moon.
Just one last kind of big picture question. You know, as a mineral owner, I would hate to see get the wording right, a drilling unit boundary well ever be the holding well of mineral rights. And so that's why we have this stipulation that you drill the 2 first to hold those. I can't think of any way to remedy a situation where one of those wells that are within the drilling unit don't work out. And so then you have the drilling unit boundary well holding the well because you've now paid on a 25/60 basis. But I was just wondering if there were any thoughts from you on how you could remedy that situation where a well was holding some or all of 25/60. Just any thoughts on that?
Yeah.
I was going to say, I mean, we're not essentially planning on only putting one well in each of the 1280s anyway. So even if there was a well that for whatever drilling failure or something could not be executed on or ended early for economic reasons, the development plan does not assume one well per 1280 to hold that section. So I think that would, hopefully alleviate concerns. I understand the concern with obviously the consolidation under the 25/60 to mineral owners and what that might mean for future leasing and stuff. But the development plan isn't just one well per 1280 to then go in and drill the drilling unit boundary well. So I don't know if you've got additional.
Yeah, I mean, I honestly don't know that there is a protection per se, but the board does have inherent authority, and I guess it could look at the order and say that the spirit of the order wasn't met because there isn't a 1280 holding those 2 sections, and maybe the division could file a notice of agency action to have the operator come in. I don't know how well that would work, but that's my first kind of off the cuff thought is some sort of a notice of agency action to say,
Require a well be drilled there.
hey, there's no 1280 here. But most operators, like Ms. Ryan said, there aren't that many operators out there who are looking to hold sections of land. Obviously, that's a necessary component of what they do. But as far as, raising capital and getting rate of return, you have to be drilling to be surviving. So, thank you. Yeah.
Back to you, Mr. Mayo, for summation and admission of exhibits.
Thank you, Mr. Gill. In summation, I'd like to remind the board that this is identical to the request that Altamont presented in July. This is essentially a request to extend and include the two westernmost sections in that cause number 139-165. Altamont believes that there are real operational efficiencies and an opportunity to increase production from an area that has been targeted fairly extensively for vertical development and hopefully bring some new production to an area that has had historical production and historical depletion. All regulatory and statutory matters have been met in this case, and pending, of course, the BLM and BIA response, if any, in January, Altamont believes this is the appropriate approach to put these lands back into kind of looking forward productivity. And with that, I'd submit.
Thank you very much. Let's submit the exhibits at this time.
Yeah, Chairman Gill, I'd like to move to admit exhibits A through O. If the board would like us to admit the resumes, those are contained in exhibit.
Yes.
Those are contained in exhibit P. Then I'd like to move to admit exhibits A through P.
Division, any objection?
No objection.
Board members? So admitted. And then would you like the board to have take administrative notice of the orders in dockets 139, 154, and docket 139-163?
Thank you. I did miss that in my introduction. I appreciate you catching that, Chairman.
Okay, thank you. Okay, the matter is now before the board. What is your pleasure? A motion to approve the request for agency action is
I move that we approve this request for agency action.
Is there a second? Any discussion of that motion? Seeing none, the motion before you is to approve the request for agency action. All in favor say aye.
Aye.
Any opposed? Let the record show that that was unanimous. And then, Mr. Mayo, will you write the order, please?
I'm happy to do that.
And thank you. And I expect this to be kind of the first of what we'll see in the future. I mean, the economics of having a complete program, including the drilling boundary unit well, seems to be the way to go. I'll be interested to see how this comes out.
Well, we're excited to report next July and tell you how it's going.
Yeah, right now, are you drilling yet, or where are you at? Not yet.
Permits have been filed and are pending for the first phase of the development.
Okay. All right, well, thank you. We'll bring this matter to a conclusion. Court reporter, I would like to reopen docket number 2019-027, cause number 194-03 in the matter of Wesco Operating. We were asked to take judicial notice of the prior flaring orders. Board members, do you have any objection that those orders be included in the record? We didn't rule on that, and that was just something left hanging.
Did those prior orders have economic analysis? Oh, okay, back when we, okay.
We absolutely
Okay. So is, board members, can we have a vote that the judicial notice of the prior flaring orders as mentioned in the testimony be taken by this board under judicial notice? It just becomes part of the record. They can refer to it. It's that's that simple. Okay, all in favor say aye.
Aye.
Any opposed? Let the record show that was unanimous. Okay, we'll close that matter and move on to agenda item number 5. In the matter of docket number 2019-026, cause number 007-15, in the matter of the agency action of the division regarding Spencer K. Barton and the Academy #1 well, among other issues. We'll take a notice of council at this time.
Gordon Rowe for the Utah Attorney General's Office for the Division of Oil, Gas, and Mining. And this matter has been continued to the January board hearing. We were unable to effectuate service on Mr. Barton, but we were able to serve him in the Emery County Jail in time for the January hearing.
Okay. Let the record show that that matter is being continued. We have one more agenda item, I believe, and that is docket number 7. Okay, pardon me. Board Counsel, Mr. Begley, could you come tell me what? Yeah, we're going to have a 5-minute break. We're going to have a break now, and then we'll come back and address the agenda item number 7. Board members, would you meet me in the break room? Okay. Okay, we're back on the record. We're at docket number, or pardon me, agenda item number 7, docket number 2017-013-A, cause number RONG-2017-01-A. I think that's a matter, just to note, Board Secretary Julianne, what we'd like to do is refer to the rulemaking dealing with operatorship be designated the same, except it be B, and that the rulemaking regarding horizontal drilling rulemaking be designated C. Any questions or comments on that? Okay. All right, we're on number 7. The board is going to ask Mr. Begley to give us a recommendation.
Thank you. First, Chairman Gill, could you please ask whether there has been any further written comment?
Okay. Natasha, would you come up here and for the record, identify yourself and tell us what comments have come in since the deadline was today at 5 p.m.
Okay, I'm Natasha Baliff. I'm the Legislative and Policy Coordinator for the Division of Oil, Gas, and Mining. There has been no additional comments, or there haven't been any comments since the November 25th meeting that we had.
Thank you very much. Okay, we're to you, Mr. Begley.
Thank you.
My understanding. Not picking up, Mr. You got to be closer.
My understanding is that counsel for both of the parties that participated in the formal hearing have been.
Are those parties?
Mr. Furlong and his counsel, and I believe there were several other parties represented by Mr. Hunter and Utah Petroleum Association, which was also represented by Mr. McDonald. They have been negotiating since that hearing and are in the position, or at least notified, at least myself, that there could be the possibility of arriving at some sort of compromise that could then be formulated into a rule where everyone would be on the same page and that we could proceed forward to having that formal rule become effective. However, that has not occurred as of right now, and we are now in formal rulemaking. So the board could be in a position to either rule that this is an effective date on the proposed rule now, because we do not have a change in the rule as of right now. So my suggestion is that, and my recommendation to the board is that you allow board counsel, division counsel, and the two previously identified attorneys to have a conference call tomorrow to, one, resolve timing and whether or not we can receive before the 15th or whenever we have, now that this is formal rulemaking, that we could get a compromise rule in place. And two, whether or not, if that is the case, whether the Office of Administrative Rules will allow us to file a change in the proposed rule, which my understanding is there is a system issue that we need to have it worked out. So the bottom line is we do need to have a conference call with counsel to make sure that we inform the board of the status of A, are we going to have a change rule in place, and B, can we do a change in the proposed rule amendment with the Office of Administrative Rules within the time frame under the formal Rulemaking Act, which is where we're at.
So as I understand that, that would be a conference call among counsel.
Correct.
And their clients, but mainly a counsel, and then there would also be a conference call with the board.
The board would have to have a quorum to make sure that we have a formal vote on what is occurring once you have all the information.
And then that discussion could be ratified at an open meeting in the future?
Correct.
So that there could be, meet the needs of the Administrative Rulemaking Act. Okay, board members, do you feel like you understand what we're doing today? So is the best way to do that to say that this matter is continued? Or put on hold? What is the best term? And then Mr. Baza, do you have any comments that you'd like to make regarding this?
I don't have anything to add what Mr. Begley is saying, but you know, let's not forget that the board has the opportunity to convene electronically if you desire to do that.
Oh, that's true.
And
We could do it
we could
electronically
certainly
as well.
We could certainly make that happen.
So I think it's better to have a conference call, but that would be, and then we could have an electronic voting or any combination of the above.
Chairman, I think the best thing to do is just to say the board is not going to take any action today on the formal rulemaking matter.
Okay. Board members, a motion is in order to say that we're not going to take any action on this matter today.
I would so move.
Okay, is there a second to that?
Second.
Okay, any discussion? The motion before you today is that in this matter of the formal rulemaking under cause number RONG-217-01-A, that we would not take any action today. And then I would like to do one bit of clarification, though, and that is, board members, that as to what we have heard to date, that we would take judicial notice or administrative notice of the record in the informal rulemaking so that if we are to get to that, the record is complete on that matter. And Council, do you concur with that?
I do.
Okay. So, board members, I need a vote on that. All those in favor of taking administrative notice of the record in the informal portion of the rulemaking and the hearings and the written comments, all in favor say aye.
Aye. Aye.
Any opposed? Let the record show that was unanimous. I believe that takes the end of this matter then.
Did we vote?
I don't think you voted on the motion.
Oh,
You made the motion, it was
okay.
seconded,
We
we
had a
didn't vote.
Now, as to the motion in chief, as to take no action on that, all in favor say aye.
Aye.
Any opposed? Okay, let the record show that was unanimous. Thank you very much. We are now stay there. We are on agenda item number 8, docket number 2017-013, cause number RONG-2017-01. As I mentioned in the previous one, we want to bifurcate that into a B and a C. The B part of it would be the proposed rulemaking on operatorship, and the C component of that would be the proposed rulemaking on horizontal drilling. Thank you. As part of that, I guess the first part of that is to ask the division whether there have been any objections to the proposed scheduling order.
Mr. Chairman, members of the board, John Baza with the Division of Oil, Gas, and Mining. As far as we know, there have been no comments or suggestions regarding the scheduling order. I know that, you know, off the record, I've received people saying, you know, what is going on here and wanting to get more information, but nothing has been filed with us. And you've seen the draft scheduling orders that were previously filed with the board in these matters.
Thank you. So that being the case, proposal before you is to approve the proposed scheduling order, which would be sub-dockets B and sub-docket C. Are we clear on that, Board Secretary? Okay. A motion would be in order to adopt those scheduling orders. Is there a motion?
Would make that motion.
Is there a second?
Second.
Okay, any discussion?
May I, yes. Mr. Baza, does this schedule comply with the discussion we had at the board meeting that I chaired about the appropriate way to go through rulemaking? Is it copacetic with what you asked for there?
It's a little bit different, but we can accommodate it. And I think that with what has been put in place, it's obviously an aggressive schedule of rulemaking, but and I can report to you that we've had one meeting with the Utah Petroleum Association on operatorship and horizontal rules. We're having another meeting scheduled in early January to discuss those same things. I think as I read the scheduling order, we basically have January, February to be able to finalize those things. Whether we come to a consensus or not is a different question, but we will push forward and try to meet that special scheduling order as it is written.
Mr. Chairman, several of you were not at that meeting, and Mr. Baza made a presentation to the board members that were there, asking or clarifying and helping us understand the normal procedures and schedules for rulemaking. I wanted to make sure he felt comfortable with this schedule relative to that instruction.
Thank you very much. Okay, we're to a vote. All in favor of, let's bifurcate that, for the scheduling order in docket number 2017-013-B, cause number RO&G 2017-01-B. In favor, say yay.
Aye.
Any opposed? Let the record show that was unanimous. In terms of docket number 2017-03-C, as in Charlie, cause number RO&G-2017-01-C regarding horizontal drilling rulemaking. All those in favor of the scheduling order in that matter, say aye.
Aye.
Any opposed? Let the record show that was unanimous. With that, I believe we're through with today's hearing. Is that correct? Anybody have a reason to talk further? Seeing none, a motion to adjourn is in order. It's non-debatable and doesn't need a second. All in favor, say aye.
Aye.
Thank you all, and let me take the chairman's prerogative of thanking the board for all you've done in the last few years in the division, and Paul and Tom. The microphones are working better, at least from that side. We now have people testifying over television. We've got, as today, we've got new computerized programs for tracking issues. I am so proud of the division and the board, I can't tell you. And then to the council and those that are still here, thank you for your input. It's been very helpful. And to all of you, we wish you a very happy holiday season, and for you and your families and those that are important to you, significant others, whatever. We wish you the very, very best. And with that, we're adjourned.